up at the hearing. I'm not so sure that they'll apply, but you can try. Please, I don't make those decisions. It sounded like he's the property owner. He said the neighbors were chasing me.
I think the wines will be part of this thing. 4 years from now, I try to be. Because this year is
Well, according to the photographs, yeah.
and I think the party needs to go itself.
I've got like two. This must be
People watch the next reality. Clinton has got to be livid at Sanders, so I mean, she's going to win, but he's just like eating up time and energy from her. It's just the lowest. I think both candidates have the lowest rating. Nobody likes either one of them. Just like,
It's a sad state of affairs.
13 is consent.
There's a change.
Yeah, this one's going to consent, which is unusual.
maybe it's a sign. All right.
Thank you.
Okay, good afternoon. We're going to come to order. And good afternoon and welcome to the May the 17th, 2016 convening of the Baltimore City Board of Municipal and Zoning Appeals. We're going to get underway. Before we do that, just a few house rules. First, if you have a cell phone, a pager, anything that makes any kind of audible, electronically generated sound, or even if it makes any generated sound that's not electronic, we ask that you please, at a minimum, turn that to a vibrate only, if not off position. Additionally, to the extent that you need to have a conversation with someone, we please ask that you take those conversations out the double doors to your rear. The reasons for those rules are pretty simple and straightforward. First, cell phones, pagers, and the like going off in the gallery to disrupt the general conduct of these proceedings, as well as the recording of these proceedings. Similarly, conversations in the gallery disrupt the conduct of these proceedings, as well as the recording of these proceedings. Additionally, you'll note that there are a number of microphones which are arrayed around us up here, and those microphones are all very sensitive. They're not only for the purpose of amplification, but they're also for the purpose of recording. And if you turn around and you see there are 3 video cameras mounted on the walls behind you, and there are 2 video cameras which are mounted on the walls up here behind us. And these proceedings are being recorded for broadcast, as well as being transcribed contemporaneously. So conversations, cell phones, pagers, things going off disrupt that process as well. We will be voting at the end of the day, and you're certainly more than welcome to sit around and enjoy a civics lesson if you so choose. But if you have other plans for this rather splendid May afternoon. That's certainly understandable. And you can call into the zoning board office after your case. I guess you can call in the zoning board office tomorrow to find out how the board ruled on your case. And if you take out pen and paper, I can read you off the number for the zoning board office. I'll read this number off a couple of times to give you some time to get it down. That number is 410-396-4301. Again, that's 410-396-4301. You will, however, need to wait until you receive the formal written notice of the outcome of your case. That should be forthcoming in about 3 to 4 weeks before you'll be able to get your permits. And we certainly ask you not to build in the city of Baltimore without first obtaining all of your proper permits. If you haven't already done so, if you are here in opposition to any case today, we ask that you please sign in on our sign-in sheet. It's being held up by Mr. French there. The sign-in sheet allows us to know generally which cases have opposition, but also allows us to know who needs to receive those aforementioned written notices I just referred to. Additionally, if your case gets postponed, we need to know how to contact you and let you know when your case will be going forward. So please, if you are here in opposition to any case, make sure that we've got you reflected in the record by signing in on the signing sheet. The procedure for when the cases are called is that if you are the appellant, you'll come forward and you'll stand to our left or your right. The opposition, if any, will stand to our right or your left. Once everyone is up here, we'll get you all sworn in, and we'll begin first with the appellant, who'll be given the opportunity to present their side of things, present their witnesses, their documents, and generally argue their positions, as well as respond to any questions that the board may have. Once the appellant has concluded their presentation, we'll then turn to the opposition, who will be given their opportunity to present their side of things, their documents, witnesses, and the like. Once the opposition is concluded, we'll return back to the appellant, who will be given the opportunity to respond to any points brought up by the opposition, and then be given the opportunity to give a closing statement. We will not be going back and forth, unnecessarily delaying things and keeping folks here longer than is necessary. We will generally be calling the cases in the order in which they appear on the docket. After we first dispense with some preliminary issues, I guess the only one that we have today are those cases on our consent agenda. The consent agenda consists of cases where the zoning board staff has already reviewed the files and the board has determined that there is sufficient information to approve these appeals based on the records submitted. We're going to call all the consent cases as a group, so you can listen up to hear if your case is called. If it is, you'll come forward. The first person will stand here in front of this microphone, and all the other cases will then line up behind them down the dais. Once everyone is up here, we'll get you sworn in as a group, and then we'll call each case in turn that's on the consent agenda. And then once your case is called, you'll be given the opportunity at that point to provide any information that you would like to have added to the record. First case on this consent agenda is 2016-88, 5506 North Charles Street, Ryan Grubb. Case after that will be 2016-107, 3006 through 3052 West North Avenue, Caroline Hecker. After that will be 2016-113, 2240 Cambridge Street, Jennifer Cuffley. Then will be 2016-115, 113 York Court, Adrian Bishop. Then we'll have 2016-121, 2421 Fleet Street, Bill Silander. And then 2016-122, 134 East Austin Street, Stuart Stark. That will get to 2016-124, 1112 South Conkling Street, Charles Lambourne. And 2016-125, 343 South Chester Street, Nicholas Nagy. have 2016-126, 2507 Foster Avenue, Inan Samarat. And 2016-128, 502 through 518 North Castle Street, Nate Predel. And finally, we'll have 2016-131, 909 South Highland Avenue, Brian Dick. Okay. All right, if all those giving testimony will raise their hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, calling the first case, 2016-88, 5506 North Charles Street, Ryan Grubb.
Yes, sir.
And you're Mr. Grubb?
Yes, sir.
All right, Mr. Grubb, we have this as an application to construct a 5-foot-high fence in the side yard along a street. Is that correct?
Yes, sir.
All right. And Mr. French, is there anything from the planning department?
Martin French for the Baltimore City Planning Department. Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Grubb, anything you would like to have added to the record at this time?
No, sir.
All right. Zoning board staff, having previously reviewed your application, we've determined that there is sufficient information to approve your appeal.
Thank you.
Thanks, good luck. Next up, 2016-107, 3006 through 3052 West North Avenue, Caroline Hecker.
Good afternoon.
Afternoon, Ms. Hecker. Thank you, Mr. Williams. And Ms. Hecker, we have this as an application to consolidate the lots, construct a 4-story, 65 dwelling unit and retail space building with 15 off-street parking spaces. Is that correct?
Yes, that is correct.
Okay. And Mr. French, is there anything from the planning department with respect to this appeal?
Yes, thank you. Planning Department reviewed this application, has been working with the developer on the design of this property, recommends approval of this application contingent upon enactment of rezoning of these properties to B23, and subject to the condition that the proposed improvements are completed according to the development plan approved by the Urban Design and Architectural Review Panel. Thank you.
Thank you. And Ms. Hecker, are those conditions offered by the planning department amenable to your client?
They are, a bill is pending in the city council right now to rezone the property, and we have been through the schematic level of review, the UDART panel, and we'll continue with final design there as well.
Okay. Anything further you would like to have added to the record at this time?
Mr. Williams handed up a folder full of additional exhibits. There's a letter of support from the local community association in there. We would just like to add those to the record.
Okay, and I think we've got those. Okay, is that it?
That's it.
Okay, zoning board staff, having previously reviewed your application, we determined there is sufficient information to approve your appeal.
Thank you very much.
Take care, good luck. Next, 2016-113, 2240 Cambridge Street, Jennifer Cuffley. Afternoon, ma'am. We have this as an application to construct a 2-story rear addition and new 3rd floor with rooftop deck at this location. Is that correct?
That's correct.
Okay. Mr. French, is there anything from the planning department with respect to this appeal?
Planning Department has no comment on this application. Thank you.
Thank you. And Ms. Cuffley, is there anything further you would like to have added to the record at this time?
Thank you.
Okay. Zoning board staff, having previously reviewed your application, we've determined there is sufficient information to approve your appeal.
Thank you.
Thanks, good luck. Next, 2016-115, 13 York Court, Adrian Bishop.
Good afternoon.
Afternoon, sir. You Mr. Bishop?
Yes, I am.
All right, Mr. Bishop, we have this as an application to construct a 6-foot-high fence in a side yard along a street at this location. Is that correct?
That's correct.
All right. And Mr. French, is there anything from the planning department with respect to this application?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Bishop, anything further you would like to have added to the record at this time?
I have provided documentation. The concern is that these are Guilford, York Courts. York Court is a distinct address. Greenmount Avenue passes by York Courts, but the houses do not front on Greenmount.
Okay. All right. And I think we've got that reflected in the record there? All right. Anything further, sir?
No, sir. I have a permit from the Guilford Association.
Okay. All right. Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
Thanks. Good luck.
Thank you.
Next, 2016-121, 2421 Fleet Street, Bill Solander.
Yes, sir.
Afternoon, sir. We have this an application to construct rear and rooftop decks at this location. Is that correct?
That's correct.
All right. Mr. French, is there anything from the Planning Department with respect to this appeal?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Solander, is there anything further you would like to have added to the record this time?
No, sir.
Zoning Board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you.
All right, take care. Next, 2016-122, 134 East Ostend Street, Stuart Stark.
Hi.
Afternoon, you're Mr. Stark? You're Mr. Stark?
Yes,
Okay. Sir, we have this as an application to construct a two-story rear addition and new third floor with rooftop deck at this location. Is that correct?
yes.
Okay. Mr. French, anything from the Planning Department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Stark, anything further you would like to have added to the record this time?
No, I'm good.
Okay. Zoning Board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Great.
Okay. Good luck. Take care. Next, 2016-124, 1112 South Conkling Street, Charles Lambourne.
I'm his wife,
Okay.
co-owner. So I'm not Charles, I'm Suzanne.
Okay. And your name for the record, ma'am?
Suzanne Lamborn.
Okay. And Ms. Lambourne, we have this as an application to construct a two-story rear addition with rear deck at this location. Is that correct?
Correct.
All right. Mr. French, is there anything from the Planning Department with respect to this application?
Planning Department has no comment on this application. Thank you.
Okay. And Ms. Lambourne, is there anything further you would like to have added to the record at this time?
Just that the real purpose of the addition has to do with the staircase, that we have the original staircase in the house that's only 28 inches wide and has the tight turn, and the basement has that almost like a ladder staircase, and that's where our laundry is. So the addition is resolving those two issues.
Been there myself. All right, the zoning board staff, having previously reviewed the application, have determined that there is sufficient information to approve your appeal.
Thank you.
Good luck. Next, 2016-125, 343 South Chester Street, Nicholas Nagy.
Yes, sir.
All right, Mr. Nagy, we have this as an application to construct side and rear additions with new third floor with rear and rooftop decks at this location. Is that correct?
Yes, sir.
All right. Mr. French, anything for the Planning Department?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Nagy, is there anything further you would like to have added to the record this time?
No, sir.
Zoning board staff, having previously reviewed your application, we have determined that there is sufficient information to approve your appeal.
Thank you very much.
Take care. Next, 2016-126, 2507 Foster Avenue, Eden Samarit. Afternoon, sir. We have this application to construct a two-story rear addition with rear and rooftop decks at this location. Is that correct?
Yes.
Mr. French, anything from the Planning Department with respect to this application?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Summerett, is there anything further you'd like to have added to the record this time?
No, sir.
Okay. Zoning board staff, having previously reviewed the application, we have determined that there is sufficient information to review appeal.
Thank you.
Take care. Next, 2016-128, 502 through 518 North Castle Street, Nate Prettle.
Afternoon.
Afternoon, Mr. Prettle. We have this as an application to consolidate lots and construct three-story, 12 dwelling unit building with 11 off-street parking spaces at this location. Is that correct?
That's correct.
Okay. Mr. French, is there anything from the Planning Department with respect to this appeal?
Thank you. Planning Department has reviewed this application, noted it is in the Middle East Urban Renewal Plan area. The department has no objection to approval of this application, subject to the condition that the proposed development is completed in accordance with plans approved by the Site Plan Review Committee. Thank you.
Okay. And Mr. Prettle, is your client amenable to the condition offered by the Planning Department?
Yes.
Okay. And is there anything further you would like to have added to the record this time?
Yes, I'd just like to introduce Dr. Sivan. He's the property owner and developer. And I'd also like to add that we've been meeting with the CARE Community Association, and we've pledged to work with them on issues such as security and local hiring as we move through the construction process.
Okay. Anything further?
No.
Zoning board staff, having previously reviewed your application, we determined that there is sufficient information to approve your appeal.
Thank you.
Take care. Good luck.
Thank you very much.
Next, 2016-131, 909 South Highland Avenue, Brian Dick.
Good afternoon.
Afternoon, sir. We have this application to construct second floor rear addition with rear deck at this location. Is that correct?
Correct.
All right. Mr. French, is there anything from the Planning Department with respect to this appeal?
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Dick, is there anything further you would like to have added to the record at this time?
No, sir.
Zoning board staff, having previously reviewed your application, they have determined that there is sufficient information to approve your appeal.
Thank you.
Yeah, good luck. Okay, we're now going to turn to the remainder of our docket, which will include cases where opposition is signed in. Frequently, we found that opposition is a result of either a lack of communication or miscommunication among the parties, and it can be useful to offer the parties an opportunity to have a dialogue or enter into a have a dialogue or continue a dialogue to try to see if they can resolve whatever differences they have between them. Obviously, if two opposing sides to an issue approach the board and ask the board to resolve it, one of those two sides is bound to go away disappointed by the result. So this is your opportunity to avoid that unhappy fate. I'm going to call out the cases where opposition has signed in. I'll ask you just simply to stand where you are, and we'll ask if there has been any dialogue between the parties, and whether the parties would like to have a dialogue or would like to continue to have a dialogue. If you would like to talk, just step out the double doors to your rear. If you are able to reach an agreement, that's great. Just come in and let us know. If not, just come back in, have a seat, and we'll call you in turn. 2015-502, 910 Poplar Grove Street, Omar Abdussalam. Okay. And have you folks spoken before?
Yes, we have.
Okay. Would you like to try to see if you can get something worked out, or?
To the board, we had a 2-hour mediation Saturday and nothing was resolved, so.
Okay. Have a seat. We'll call you in turn. Next, 2016-92, 3414 Seneca Street, John Frankel.
Yes, sir.
Okay. And who's signed in on that case? Okay. And have you folks spoken, had a dialogue? No. No? Okay. Would you like?
But there's not gonna, there's not gonna be one, I'm sorry.
Okay.
You know, I feel like he brought these, they look like shipping containers, and put them right in back of his backyard, 2 of them.
Okay. Would you folks like to talk, see if you can get something worked out?
I would ask that.
Okay. Have a seat. Next, 2016-112, 2053 East Monument Street, Michael Collins. Okay, and have you folks spoken?
I tried, but he's not listening.
I
Well-
have a restraining order that was given to me for him not to be around me, so therefore there's nothing we can
That's
say.
why I say we tried.
So it's up to the board to make decisions.
Okay,
Fate.
all right, have a seat. 2016-123, 1448 North Mount Street. All right, and have you folks spoken?
Yes, on the phone.
Yes, I think, yeah, we spoke on the phone.
Had a long conversation.
Okay, would you like to talk and see if you can get something worked out?
She's willing to talk, I will talk to her again. She's willing to talk to me because she pretty much just got hung up on me on the phone. She wanna talk, I will try talking again.
Yes, so he would like to speak. Doesn't hurt.
I can listen.
Okay, great. That's all that's required. If you get something worked out, let us know. Just come back in. If not,
We
yeah,
come back in
that's fine.
regardless, right?
What? Oh, yeah, yes.
Oh,
yes,
okay.
Yes. You're a little bit far down on the list, so you got a lot of time. Anything else? Nope, that's it. Okay. We have a couple ones here. Okay, I'm gonna jump around a little bit. 2016-109, 4207 Groveland Avenue, Stephen Obegna. Okay, sir, we have this as an application to increase occupancy from 4 dwelling units to 5 dwelling units as a multiple family detached dwelling. Is that correct?
I think I wrote it wrong. I want to use it for a studio. It's only one room. It's not
Okay.
an apartment. It's a studio, no There is no living room, there is no dining room.
Okay, we can get into that, I guess, once we get
Okay.
into the case. Why don't you raise your right hand and be sworn, please?
Swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. First, do we have staff reports?
I have nothing.
Thank you. Planning Department has reviewed this application, noted that this property was previously the subject of a zoning appeal in 1959, at which time the board disapproved the same request for 5 dwelling units. The property contains only 11,250 square feet of lot area. It is well below the amount of lot area required, 32,850 square feet, to support 5 dwelling units. The amount of variance that would be required for the board to approve would be 66% approximately, which is well above the 25% maximum that is provided as discretion to the board in the zoning code. For these reasons, the Department of Planning recommends disapproval of this application because the amount of lot area variance required for approval would exceed the board's discretionary authority provided in the zoning code. Thank you.
Thank you. Okay.
Can I make a comment?
Obegna.
Yes.
Obegbena.
Call me Steve, that's good enough.
Okay. Now, you said that you believe that that this was written down incorrectly.
Yes,
We're actually looking for something else.
okay.
All right. So why don't you tell us what it
Very
is
well.
that it should be?
I've been in possession of the property for, I think, 16 years.
Okay.
Okay? Nothing has changed. The same square footage is the same. The only thing that changed was, in fact, I would say I'm naive. I've lost $72,000 in revenue for 10 years because students from Morgan State and Coppin State, they've been approaching me, to use it as a studio, So in my mind, I kept thinking it's an apartment. So I proceeded forgive me, I have to invoke his name. When my friend was alive, is it Mr. Little, Small? All right, he saw the square footage. If you look at the plan, it will ascertain that it is only one room. You have the plan in your possession.
Well, as I understand it, the
It is not
building
an apartment.
currently has 4 dwelling units. And is it that you're trying to say that you're looking for an efficiency?
It's really not, it doesn't really qualify for an efficiency. It's 10 by 15 room. And then,
Which, excuse me. Does it have a kitchen?
yes, it does.
It's a dwelling unit.
Okay.
This property is in an R2 residential district. However, in an R2, there's no distinction drawn between an efficiency unit and a full dwelling unit, which implies that efficiency units just don't. You can have an efficiency, but it's still treated the same as if it's a dwelling unit. There's no difference between the minimum lot size requirements for an efficiency unit than there is for a 1-bedroom or 2-bedroom dwelling unit. That's it.
That was my conclusion too, because the inspector I called to look at it said it qualifies for, that I have been, in fact,
it
given
may
the
be-
wrong information. so
It
to say.
may meet the definition of an efficiency unit, but the minimum lot size required for that unit is the same as if it were a full dwelling unit.
Meaning,
Meaning,
You still have the same burden of the minimum lot size requirement being met, and in this case, you're requesting a 66% variance of that, and the board has the authority, without any other extenuating issues, to only approve a 25% variance. So that's the difficulty that you have to
okay,
overcome.
in that case, I have the discretion, from what I'm told, to make the whole second floor one-unit apartment because the square footage has been in existence since I purchased this property. There has been no addition, no subtraction, nothing.
That would still be considered to be 4 dwelling units, and you
Okay,
already have
fine.
permission to do that.
Very well. So that's basically what I'm going to do then.
Okay, well, we wouldn't really, you wouldn't.
That's
need
up to you.
I don't have to discuss it. Okay.
Yeah,
I
yeah,
got
that
you.
wouldn't be anything that you would need to come
Very
to
well.
us for. But just to.
I was just trying to accommodate all these students, basically. Because, but if I can't use it for that, then I use my discretion. Like,
Okay.
all right,
Is there anything further?
that's it.
All right, all right, I think I know how we'll handle this. All right, thank you very much.
Thank you.
And we'll jump to 2015-130, 55 South Morley Street, Michael Jones. Okay. All right, you're Mr. Jones?
That's correct.
Okay, and Mr. Jones, we have this as an application to house 2 dwelling units as multiple family attached dwelling at this location, is that correct?
That's correct.
Step up to that phone there. All right, if you can raise your hand and your right hand and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, do we have staff reports?
Planning Department reviewed this application, noted that this property was authorized for use as a two-family or multiple-family dwelling by the board's decision made in 1969, which predates the adoption of the current zoning code, which made this use non-conforming in an R6 zoning district. The department basically, under these circumstances, has no objection to the application, provided that the use of the property as a multiple-family attached dwelling has not been discontinued or abandoned prior to this. Thank you.
Okay. Mr. Jones, why don't you tell us what it is that you have planned for this location?
Well, basically, the previous owner had started rehabilitating the property and moving it in a direction of having it set up as 2 units. The owner passed away. We purchased the property on 4/25/2016 with the intentions of continuing that rehabilitation. I believe at some point there was a housing citation issued to raise or rehabilitate the building as recently as 2016, March of 2016. Again, we've started, again, 80% of the rehabilitation has been completed. We have run into some difficulties in acquiring the permits to complete the rehabilitation based on the zoning, the current zoning, because it had lost its zoning based on the fact that it had been sitting vacant for about a year.
Okay. And, Mr. Jenner, what do we have as far as citation history?
We do show that the vacant building notice issued the first one was issued in 2005, and then another one in 2014. So I don't know if, I can't say it's been vacant since 2005. It most likely hasn't been. Probably got occupied and then vacant again at some point along the way. There's no dispute that it was 2 families, but because it was vacant, the zoning administrator's office disapproved the application and sent it to the board.
Okay. All right. And so do you know, well, I know you said that that prior owner had been trying to renovate it and then passed away. Do you know when, or maybe, is there something in the permit history, David, that shows when they started pulling permits for that one?
I believe it was in 2014 they had pulled permits for windows and drywall work.
Okay.
So as recently as 2014, it had been occupied.
Okay, well, we know that in 2014, it wasn't occupied because it was issued the vacant building notice.
Well,
And then
shortly
there
thereafter
was-
that, yeah.
And then there was the permits that were issued that same year.
There was a permit issued 10/24/13 for alterations, interior work, things like drywall, replace windows. But that was for the work only. It didn't indicate the number of dwelling units in
Yeah.
on that permit.
And then
And then
when was the citation in 14?
February 6th. And this permit for the work was issued on 10/24/13. So they had the permit in hand. I guess the building was unoccupied, and subsequently a vacant building notice was issued in February during that process.
Okay. And what kind of renovation work were they doing?
Well, a lot of interior work, some, I believe they replaced the windows, a lot of the drywall, replaced a lot of the doors. And I think a lot of the work was conforming with some of the citations the requirements of the citation, meaning to secure the doors and windows, clean up the debris, clean up the area in front and back of the location. And I believe most of the work was focused on that, and also, again, some of the drywall interior work as well.
Okay. How much of the interior work would you estimate was completed?
Again, I would estimate around 70 to 80%, because I believe a lot of it had to do with just, drywall work. There was some water damage that had occurred that they were in the process of repairing. So I guess, again, we're right around the 70 to 80% mark of completion. And we've, again, had to stop because some of the permits do require us to have it zoned as a two-dwelling unit before we can continue any further rehabilitation.
Are there any questions?
No?
Thank you.
Thank you, sir.
That's right here. 2016-129, 1604 Webster Street, Joseph Haney.
Sorry.
Just come right to that one there. Okay, Mr. Haney, we have this as an application to construct a second-floor rear deck onto a single-family attached dwelling at this location. Is that correct?
Yeah, it's not attached, yes, but it's not attached to the unit, and it's about 6 feet off the ground. So it's not actually physically attached. It's not, and that's not the second floor.
Okay. All right. we
The
can
house
get
is
into-
raised about 4 feet, about the ground now, yeah.
All right, we'll get into that.
Sorry.
If you can raise your right hand and be sworn, please.
Sure.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Do we have staff reports?
Planning Department has no comment on this application. Thank you.
Okay. All right, Mr. Haney, why don't you tell us what you have planned here?
We're looking to build a deck on the back of the unit. It's the width of the unit and then the full backyard.
Okay.
So the deck, it's about 14 by 15 and a half.
And the deck would cover the entire backyard?
Correct.
Can it be off the second level, you said?
No, it's slightly above the first level. So it's about a 4-foot drop from the first level to the cement pad. And this would be about 2 feet above that. So it's about 2 feet above the first level. It'd be below, honestly, it'd be below the windows on the first level.
Okay.
So the access to the deck is from the exterior of the property?
So you'd have the ability, yes, you could actually enter it from the exterior, or there'll be a staircase from the back door up to it.
Okay.
Okay. Any questions?
No.
No?
All right, thank you.
Okay, thank you.
The drawing is pretty relaxed, I think it's on there.
Yeah.
Yeah.
That's all right.
We go to 2016-127, 311 South Washington Street, home 9. Afternoon, sir.
How you doing?
Mr. Nunn?
I'm Myra Clark, representing Elite Contracting.
Okay. And Mr. Clark, we have this as an application to construct a 3-story rear addition onto a single-family detached dwelling at this location. Is that correct?
Yes.
Okay, if you can raise your right hand and be sworn, please, sir.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Clark with an E or without?
Without an E.
Okay, do we have staff reports?
I have nothing.
Planning Department has no comment on this application. Thank you.
Thank you. And Mr. Clark, why don't you tell us about what's planned for this location?
Well, per the construction permit, planning to build a new first floor addition and second floor addition and a third floor rear deck with staircase.
In 2015, there was an appeal to construct a 2-story rear and a new 3rd floor.
Right.
Has that been constructed?
Well, we have the, I have the resolution here, so it's, and I think that's November 19th, 2015 you're speaking of?
Yeah.
Okay, so it says, after giving public notice, reviewing the zoning records, holding a public hearing on November 17, 2015, all data submitted, it looks like it was approved on April 21st.
So
Yeah.
now you're making it a little bigger.
Yeah, we're just making it a little bigger.
Has that been, has the work started on the first one that was approved, or you're doing it all now?
We're doing it all now. We're just waiting to do it all up.
Basically, you're amending your request from that time to make it a little bigger.
Yes, sir.
I understand, okay. That's what the drawings reflect.
Yes, see.
And that appeal in 2015 was approved on the consent docket.
It looks like you're basically adding like 200 square feet.
Yes, that's correct.
Why the change?
Just more appeal.
I'm sorry?
That's what they wanted. So that's what we're trying to give them.
Okay. Any questions?
No.
Thank you.
All right, thank you.
All right, calling 2015-502, 910 Poplar Grove Street, Omar Abdussalam. Okay, Mr. Abdussalam? We have this as an application to use the first floor as a food store, grocery store, meat market, bakery, and delicatessen. Is that correct?
Yes, sir.
Okay. If all those intending to give testimony can raise their hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Yes.
All right. Do we have staff reports?
Yes, first we have a letter from the president of the Franklin Town Road Neighborhood Improvement Association. He writes, as a resident of the community, first and foremost, I strongly oppose this type of establishment of operation within the shared boundaries of the Franklin Town Road, Winchester, Landvale, and Aruna communities. Within that block, starting from 9010 through 900 Poplar Grove Street, here are my list of reasons as follows. 1, the consistency of the illegal sales of drugs and usage. 2, males ages 13 to 30 loitering at all hours of the day and night. 3, harassment of the young and especially the old by drug dealers if one is just walking by while dealers are asking or wanting folks to purchase their illegal goods. 4, the trash and debris that continues to lay along the sidewalk and gutter. 5, gunfire. 6, prostitution. 7, the operational business hours from 8 a.m. to 12 a.m., 7 days a week, seems to me unacceptable. St. Edward's Catholic Church, which is across the street, which is a pillar of the community, as a house of worship would be less appealing for most attendees if the store is allowed to be established. 8, more added traffic congestion within the block affecting traffic flow even greater along Poplar Grove Street. 9, residential parking for those neighbors who live within the 1 block radius would be an issue. Please note, in the month of December, Mr. Lem Kesno, who is handling the legal business on behalf of the applicant, introduced himself and spoke mostly on behalf of the applicant. He went on to state that the members of ARCO, we would like to bring something better to the ghetto. Those of us who were in attendance were shocked. For someone who considers the area as a ghetto, why would he be a businessman who wants to open up a business that is described as an upscale sub-carryout? What is to be considered an subscale stub carryout? Greasy foods, high in cholesterol, blood pressure, diabetes within the inner city communities. In closing, we all understand that the review of the zoning board are not in favor of anyone stating communities are already overcrowded with more and more mini-marts, liquor stores, and convenience stores. But when does it stop? The inner city has already been damaged by liquor stores, corner stores. What more is there? Please do not allow this to happen. There is a shopping center called Princess Plaza that has plenty of room for more businesses of this type of establishment. What we need, which would be more helpful, would be a bank. There's a letter from the Aruna Association. They mention many of the same things, but they make the accusation that the neighborhood is already saturated with pretense food markets that are nothing but snack and junk stores. They talk about the excessive amount of trash. They would like to have the businesses start to change their culture about trash. The atmosphere of smelling trash and urine, the lingering young men, the women lingering in front of establishments, property values decrease, and new homeowners become absentee landlords for properties. Stores in this area just do not bring income to the area. And there are letters from residents at 3009 West Landvale, 952 North Franklin Town Road, 954 North Franklin Town Road, and 956 North Franklin Town Road in opposition. Does planning have a report?
Thank you. Planning Department reviewed this application, which was for a carry-out food shop. Noted that this property was last authorized for use as a delicatessen by the board in 2012, which at that time was an authorization to change non-conforming use in this R6 residence district. The application provided with this particular appeal indicates the premises currently are vacant. The carryout food shop is not a use listed in the B1 district as a permitted use, and therefore it is not eligible for a change of non-conforming use, even if the non-conforming use is still in effect as previously approved by the board. The Department of Planning therefore recommends disapproval of this appeal because a carryout food shop cannot be approved by the board as a change of non-conforming use on a property located in an R6 general residence district. Thank you.
Carry out food shop.
Sir, if you can identify yourself for the record, please.
My name is Alexander Lane McKenzo.
Okay, and you were saying, sir?
No, it's not gonna be a carry out food shop. We didn't know.
Okay, so I had asked beginning what if the description of the appeal was accurate. So
Yeah, you said grocery store, meat market, delicacy, and
Yeah,
you said
we did not put that on their application.
say it again, sir.
We did not include carryout in this request.
Oh, you did. Oh, okay. I just thought.
But previously there was.
Yeah, previously there was one. Previously.
okay.
Yes.
All right. All right. Why don't you tell us what the plan is for this location?
Okay, yes. The plan for Mr. Omar is just to open up and do business. Like, we made a commitment to attend all the monthly meetings that the Mr. Robert Hunt is the president of every Wednesday at the church. And we also submitted a proposal because I typed on agreement, but in the previous hearing date, you said that, you know, an agreement has to be signed by two parties, and no one was willing to sign the agreement, but we still will, excuse me, I'm a little sick, you know, but we still will commit ourselves to everything we put in the agreement. Mr. Omar has agreed to have security cameras that'll be available for view by by Mr. Robert Hunt or anybody who wishes to review them. He committed himself to hire 2 people from the community. He also committed himself to have lighting in the community, and there's a lot of complaints about drug trafficking and, like, you know, people loitering. But I mean, with someone being there, it'll be better for the community because someone's there. They can call the police if there's illegal activity. It'll be recorded on video that can be submitted to the police to review to catch the suspects who's doing any illegal activity. And he spent a lot of money in this place, and you know, I just think it's unfair for someone like him. You know, we're both the same age, young, and, you know, it'd be very unfair for him not to be able to, you know, go forward. And he's just an outstanding citizen. And everybody here, they're good people. You know, Mr. Robert Hunt, I really don't have too many bad things to say. I don't have nothing bad to say about him. You know, he's a good guy, actually. And, you know, I would just humbly ask you guys just to approve this application because, you know, he spent a lot of money, between $40,000 and $50,000 into this place, and it's just been sitting since December. You know, he's just been losing and losing and losing. And, you know, we'll commit ourselves any problems, you know, if they feel as though he's not cleaning up in the neighborhood, he's not doing anything that he's supposed to do. You know, I told them in the agreement that I wrote up that was submitted as an exhibit that if a letter is submitted, you know, they can bring it up at the monthly meeting, and a letter is submitted and another letter is submitted. I told them that, you know, we'll willingly withdraw the right and tell you guys to yank our number, you know, the use number that you guys would provide us to open up to file for the permits to do business. And he's not going to exacerbate any issues that don't already exist in the community. Like, you know, a lot of issues they're talking about are police problems, and they need to bring these issues to the police. You know, the police need to go out here and do a better job, you know. That's what my personal opinion is. So, and that's it. I mean, I don't want to talk you guys to death, but I mean, he's just going to be an outstanding guy. And these people here, they're outstanding people too. You know, he just wants to please the community, Mr. Robert Hunt. And that's it.
All right.
Thank you.
All right. Sir.
Good evening to the board. My name is Robert Hunt. I'm the president of the Umbrella Association of 18 different communities in the area. I would like to put in the record 2 letters from 2 of the institutions that would be directly impacted by additional opening up of another additional store right in that location. One is from Baltimore City Schools, I am, dear Baltimore City Zoning Board, I am writing to have concern about the possibility of a new grocery store type store opening at 910 Poplar Grove Street. We are concerned that the current practice of O's Grocery Store, which will continue in the new stores, O's continue to allow our children to enter and purchase products during school hours. We have met with the hourly manager, and the practice have not stopped. This is a safety issue for our school, and we want the practice to stop at once. We are opposed to the opening of their new grocery store type store. Sincerely, Hope O'Neill, the principal of Alexander Hamilton AS School 145.
Have you seen this?
And the other is from St. Edward's Roman Catholic Church. Appeal number 215-502 North Poplar Grove Street. Dear Mr. Tanner, we write in opposition to the request for approval of zoning to permit a food market and delicatessen that is to be considered at a hearing on March 22nd, 2016 on the subject appeal. The property is, and you gotta forgive me, I left my glasses in the car.
I understand completely.
The property in question is located directly across the street from St. Edward's Roman Catholic Church. If granted zoning approval, the proposed business would detract from public safety and cause detrimental congregation and crowding in the adjacent neighborhood. The proposed food market and carryout would operate immediately next to the existing food market and carryout, which already is the source of accumulation of large amounts of trash, which litter both sides of Poplar Grove. In the blocks adjacent to the store, the existing store also continue to the loitering of men on the public sidewalks and steps of the homes and church property on both sides of Poplar Grove Street. The proposed food market and carryout would amplify the existing nuisance and public safety issues generated by the existing store. For these reasons, St. Edward's is strongly opposed to approval of the zoning sought in the subject appeal. And this was by the parish council.
We do have that in the record. That was read at the last hearing.
We got that one in the mediation meeting. Yeah, you read that one, not this one.
The community is really feel for Mr. Omar because he has put so much money into this building. But like we have been supporting different other businesses and things, we've been trying to bring resources to our community to upgrade it. If I was telling at the mediation in the 3000 block of North Avenue, which you just heard about, they are looking for businesses to come into it. And I mentioned that to Mr. Omar. So those are the type things that, but just right now, in that location would be just too much of a duplication of all the nuisances and all the problems that we have, that the community that would not really be improved. It's not an improver of having that business open.
Okay. A couple of questions. Is there another grocery that's operating in and around that same area?
There's one right, two houses or two buildings away from where Mr. Omar would like to open up the store.
Okay.
And that store has been a nuisance. We have all kinds of police reports about the things that have been called in on it. We have, may I?
Sure, please.
There was 103 nuisance calls reported, 19 common assaults, 23 drug outside calls for the police. I mean, the police report has been, I mean, police have been, you know, these problems have been constantly recorded, and the police do know about them, but they just haven't been extinguished to the problem, you know, to the area that it has been.
Okay. And the letter from the principal talks about, we're concerned that the current practice of O's Grocery Store will continue in the new store. What is O's Grocery Store?
That is the store that is, it's a, the store that is already operating on the corner of, I think it's,
So that's,
it's 900.
Just a couple.
okay, so we have, okay, so that's the one that's 2 buildings down that you were
Yeah.
just talking about, okay. And does this appellant have any connection to that other grocery store?
No.
Okay, all right.
And he has another grocery store that, you know, on 5137 Park Heights Avenue, that's open and operational. And we told all of them to stop by to see how he practices his business. He's just an outstanding guy.
The store,
Sure.
I'm
Yes.
sorry.
No, please.
I went by the store. The store is also located in a mall, not a mall, yeah, strip mall type commercial area, which would give him ample benefits that of having certain protections that in that type area. Where that store is located at and where he would like to open up is R6 zoning. So that is 2 different issues and way that you're looking at. But he had the store I looked at is nice, clean, and you know. But again, we have an issue, 2 different issues, apples against oranges. So we can't. But again, we can't approve because we have issues that are. If he would open up, it would be as increasing the problems that we already have.
Okay. Ma'am?
My name is Jerry Pollard. I'm at 912 Poplar Grove Street. And I just wanted to say that the community is in opposition. It's cited in the letters. And they negatively, the incidents, the current climate negatively impacts and deteriorates the area's public health, safety and security, general welfare, and quality of life for the resident stakeholders. O's is open 24 hours a day. This one will be open, I guess, from 8 to 12.
I mean,
Something
sometimes.
similar,
yeah,
I'm
8
not
to-
sure.
8 to 12, 8 to 10.
Even when the prior operator was there, the same kinds of activities still went on. There was a camera located within the store and one outside on my side of the building, and it still occurred. At this point, there's just no stopping. We hope that it will decrease in terms of the activity, but this is generational. And it's going to take a lot more than saying what you will do and actually stopping what's going on in the area. And we're trying to stop it by limiting the number of these types of stores, particularly when there's one right on the corner that does the exact same thing that he wants to do.
Sir?
Good afternoon. My name is Dewey Barksdale, president of the Franklintown Road Improvement Association. Upon last weekend, we had a mediation meeting with these 2 gentlemen, and we discussed, I discussed that the community associations within the boundaries, there are 3 of them, and probably more. But we felt as a community that they should come forth and speak to every community association. We don't know who we know who the property owner is only by property taxation. When you look online, it says WYZ LLC. We felt that we would like to meet that gentleman as well as Mr. Omar, who would be actually the tenant of the property. The actual owner, I'm not sure if he lives in Maryland or not. Silver Springs? Okay. But we would have loved to spoke to him as well, but this information was also stated to Mr. Omar, I understand, from Councilman Pete Welch's office, from his employees, who explained to him, I believe our last name is Miss Wallace. She explained that, you know, you need to speak to the community associations. And it's very important because we understand that the zoning board doesn't want to hear anything about saturation or, you know, if you got more than one business open somewhere of the same nature. But it's just that situation being placed there at the present time is not good. We did offer suggestions on different locations. All three of us did. Princess Plaza is one that basically is already set up for commercial usage. And there are a lot of vacant commercial buildings that are unoccupied right now. So that would be great, you know, to check into that. I'm so sorry that Mr. Omar invested $40,000, as he stated. As Mr. Alexander stated, he invested $40,000 and is out of his $40,000 because allegedly he didn't do his homework. And when you have someone else handling your business, which is not good, it's just like you're not going to have me as an employee and have someone else signing the checks. Me personally, when he came to introduce himself to us in December of 2015 to ARCO, to make the comment that we want to bring something better to the ghetto. Well, the area is not a ghetto. Yes, it does have its problems. But you do have a lot of influential people that live there, teachers. You have engineers. You have some lawyers. You have some doctors. You have folks that work for Social Security. It's a good area, but it does have its faults. But to add an additional store at that location presently would not be a good thing. It's just not feasible. It's not feasible. The gutter is always dirty. I mean, there's trash. People hang up on the corners, and it's not going to do anything but promote more because the gentleman is not going to tell them young guys, "Hey, get out of my store." That's not going to work up there. Trust me. It's just not feasible.
Who can tell me what's there right now?
Presently,
Yes.
You have the old store.
No, I mean in that building.
Nothing. It's where basically right now there's a sign posting stating that the business was being rehabbed or what have you, and it lets you know what it would like to be. That's it.
All right. When was the last time anyone can recall there was a business, store, or whatever in there operating?
Almost 2.5 years ago when Mr. Baloo Sang opened the store and then he just disappeared. It's been vacant for quite some time.
And before that, it belonged to a gentleman named Mr. Mack, and it was a printing.
It was a printing shop.
Printing shop, which he then made it to a small store, a little bit at a point, and then the next thing I know, that was closed down. And he used to live on Lillington Road, not too far from me, but I haven't seen him in years.
And prior to that, it was a cleaners many, many years ago, and it sat vacant for many, many years, up until Mr. Sang, I guess, purchased it and turned it into a carry-out or convenience store according to his plans.
Okay.
The last permit was issued May 7th, 1999. First floor grocery variety store with print shop. And that was per zoning board, appeal 100-99X. And then we had the appeal in 2012. And while the appeal was to add a carryout to existing convenience store, that was amended at the hearing to eliminate carryout, and that was replaced with delicatessen. But the permit based on that appeal was never issued.
Okay. All right. Sir, Art, did you have something
Yeah, I
for
had
Mr. Hunt?
To my knowledge, there's 2 apartments that are already in the building. that,
Mm-hmm.
they can-
The permits
So,
also.
like I said, it is a residential area. If there was something to be done, turn that building into the whole building to residential apartments. So,
All right.
I mean, that just my thought about the whole situation. But it has to be justified that duplication, and I mean, this community have been working hard to bring resources again. Like I said, we're working with other businesses, so we're not totally against businesses. It's just that this situation has its problems that would really amplify against the community. And so I just needed to.
Okay. Gentlemen?
Oh, I mean, I said everything I wanted to say. I think the one comment that they were referring to that I made a comment saying that my father had a bar in the ghetto, and they took this ghetto thing kind of out of context. Try to make it seem like I was maybe a bougie person or something like that. But I told him that, I mean, just even the last time during the last meetings, Mr. Omar, so it can be noted, he even bought food when he wanted to do a carryout. Spent like about $300 to $400 out of his own pocket to show them what type of food he would have on display. And even what's that gentleman's name? He was running for mayor. He was at the meeting. The black Carl Stokes was there, and he had some of the food and ate it all. So, yeah, I mean, he eat a lot. So yeah, so I mean, I'm just saying that to say that Mr. Omar, he would just be an outstanding guy there, and the stuff that they complained about, the stuff that's in his power to do, keeping the area clean, he will make a commitment to keeping the area clean, and bringing the city back to life starts with small businesses. He can't help the whole community, but he can hire at least 2 people, and made that commitment to hire 2 people from this community to work in this place of business. And, we commit ourselves to come to every meeting every Wednesday. I think there's a meeting, it's this Wednesday, right? The next meeting?
Yes.
Yeah, so me and Mr. Omar will still be there this Wednesday and every Wednesday of every month. So any issues, we will always be available every month. The only reason why we didn't attend the meeting in March is because there's 5 weeks in March, and I got the dates confused. And in April, I was out of the country in Africa. But every meeting, every month, we will be there. I mean, we will make ourselves available, and also we'll still, commit ourselves to everything we put in that exhibit that you guys have. That proposal that I can't really call an agreement, but we will commit ourselves to everything we stated in there. And that's it. I just humbly ask you guys to approve so that, he doesn't lose out on so much money that he spent. It'd just be unfortunate.
On that point, when I guess he signed the lease for the space.
Yes, sir.
And I guess there was no zoning contingency in the lease.
I haven't.
at all?
I mean, when I read the lease, I don't have it in front of me, but he asked me to look at it, and I can't remember back to back what exactly the lease. I just know it said commercial, so I'm just under the impression, he was under the impression that when you see a lease that says commercial, like a lot of people just don't know, to go down to 417 East Fayette Street on the first floor and find out, what's the situation with this building. A lot of people just don't think that far in advance, even though it's just what it is. So I mean.
Because, the issue that we're here on is whether or not the non-conforming use has been abandoned. The opposition says it's been at least 2.5 years, and it suggests it's even been longer than that it's been vacant and unoccupied. So when your client signed the lease, what was in the space, or what condition was it in?
It was like all the trash, and like the ceiling all was dropped, and the floor in the bathroom was going down, and I mean there's a lot of was mess.
Okay. Sounds like it was sort of
Yes.
All right.
And the roof is also is all over the,
The
roof.
roof or the
it was
ceiling
leaking.
for that first floor?
Yes, because of the the leak.
Mhm.
So the roof, I mean, the ceiling was dropped. And there's a lot of yeah.
All right. It sounds like it was in some pretty bad shape.
Yes, and yeah, it's a lot of bad shape.
All right. Any questions?
Anybody have any?
We already went to you. Sorry.
Thank you for your time. Thank you.
All right. Thank you.
Thank you.
Thank you all.
Take a vote, so we gotta wait till later on tonight.
Next, 2016-92, 3414 Seneca Street, John Franklin. Okay, you're Mr. Frankel?
Yes, sir.
All right, sir, we have this is an application to retain two one-story sheds constructed in the rear yard of a single-family semi-detached dwelling as authorized but later voided under building permit number COM 2015-2398. Is that correct?
I believe that is, yes, sir.
Okay. All those intending to give testimony can raise their hands and be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Do we have staff reports?
Yes. First, we have a letter that has 5 photographs attached from the concerned citizens of Brick Hill. They write, enclosed you will find letters regarding an issue within our neighborhood that began in November of 2015. A new owner of a property on Brick Hill, address 3414 Seneca Street, in the middle of the night installed 2 large shipping containers in his backyard. We contacted the city, the mayor, our city council representative, neighborhood association, CHAP, Maryland Historical Trust, to mention a few. Where we live is called Brick Hill. We worked hard years ago to have it put on the National Register of Historic Places. As a mill community surrounded by historic mills and bordered by Druid Hill Park, it is a small community of 24 homes that date back to the 1840s. The homes are situated on a hill accessed by a street in the front and behind. The homes, it is a dead-ended development. Where the shipping containers are, there is only a back alley to access on which there are 3 homes situated. The owner of the shipping containers now parks his SUV, utility trailers, etc. on this street, causing more problems. Just recently, an ambulance and police were called for an emergency of a child attacked by a dog. They were not able to get their vehicles to the home. We are hoping that you can help us in this matter. We are city people that chose to live in the city, raise our children in city schools, frequent city businesses, but have never come across any other neighborhood that has shipping containers of the magnitude of this in a very small backyard in a neighborhood that was considered a gem by the Maryland Historical Trust. We also have a letter from a resident. They repeat many of the same things. They write that they immediately contacted 311, the mayor's office, and the city representative. It took months to receive any results. Finally, a housing inspector came out and informed us that the property had a permit to have these containers in this residential neighborhood. We have not seen a permit posted, nor have we ever seen a zoning sign posted saying he's requesting placement of these containers on his property. That is the end of my reports.
Planning Department has no comment on this application. Thank you.
Thank you. Okay, Mr. Frankel.
Yes, sir.
you tell us what it is you have planned here, you contemplate here?
Okay, I needed storage for my tools, and just yard equipment, stuff like that. So I went, got the information, and applied for exactly what I wanted to do and exactly what I did. That's okay. Okay, I got a permit and began construction. And an inspector came out at some point, somewhere around that time zone, and said that I was doing something. He got report from a citizen that I was doing something wrong. So, okay, do me a favor. Can you just back off just a little bit? I mean, this morning started with the gentleman in the yellow shirt coming after me with a metal rod. I mean, it's gotten out of control. Okay, and he's come up cussing at me, and I just, there's no bailiffs or anything, and if they can just keep a little distance, I don't mind moving down, but it's gotten way out of hand. I've done everything that I know to do, by the book, responsibly, in good conscience. I've done extra trips to the inspectors. Each time the inspector says, okay, yes, this is correct, and I'm doing what I'm supposed to be doing. And even when I did go, gone down to the inspector's office, just to try to cut off anything before it starts again, because, I mean, it really, truly has become, the neighborhood against me, as opposed to, hey, I have this concern. It wasn't hey, Jeff, let's talk about this. It was the inspector's on the way down. And that's after I've gone through a lot of effort. I don't, at that point, there was no other option. I had this stuff, moved out of a house, I needed a place to put it. I got the permit, and things seemed okay. We're going into winter, and I'm not saying they're pretty. In fact, they're not. They're less attractive than I expected. Okay, and for that I do apologize, but I haven't had an opportunity to do anything to make them better. I spoke with the gentleman who's renovating a house right next to me. It's a duplex. And so he'll be selling the house. So it's very important that, that it's sellable. I mean, it's very important. I spoke with the other neighbor on the other side. I had two different fence companies come out about putting up tall fences, but that was the neighbor on the not connected side wasn't in favor of that. Was more in favor of painting or something like that. Which the people that have talked to me, I've told them, tell me what you want to do. I'm not here
Just
to.
so that we're clear, the aesthetics of whatever it is that's there
Yes, sir.
isn't the issue. Just so everyone knows, the reason why we're here is an interior side yard variance.
Yes, sir.
It's under the bulk regulations for a semi-detached structure like your home. A side yard of not less than 10 feet in width is required. And the portion of both of these units
Yes, I understand.
project into the side yard.
Yeah, I understand that.
Really, the issue is the projection into the side yard.
Yes, sir.
And frankly, the issue from our perspective wouldn't be any different if you built the Taj Mahal there. So the aesthetic
Well, and I do,
virtues
yeah.
of a shipping
I'm
container
sorry.
versus anything else really isn't what we're interested in. It's just simply you're here for a variance, and so we're looking at it from the
Right.
threshold of, the standpoint of, what's required for variance.
Okay, but just for the unnecessary record, I'm not trying to make it ugly. I'm not trying to be difficult. With weather, I'll make it more attractive.
That was sort of, you wanted to do something that was sort of expedient, and this seemed expedient at the time.
Yes, sir.
And you, I'm going to guess, figured that it would look different than it did, but it looks like a shipping container, so your neighbors are all upset about it.
Yes, sir.
But, I just wanted everyone to know, so we're all on the same page. We don't really want to hear about how much people don't want to see a shipping container in the backyard.
All right, I'm sorry.
It's just simply, you're asking for a variance to project into the interior, into your required interior side yard.
Yes, sir. I've got the footers dug, inspected, the scale drawing, all made up, and it was all approved to move those at this point. Now that they've got concrete piers and they're welded to the reinforcing steel within those piers, and the containers are full, would be really, it would be out of, it wouldn't be something I could afford to have done or do myself. I did do everything possible to follow the rules and make sure that I was getting good guidance, but it's kind of a fine detail, and it got missed along the way. When it was approved. And so what I'm asking of you is to grant this variance based on, I was really doing what, exactly what I said I would do, what I thought was okay, and what I verified with the city was okay. I understand that it's not.
Okay, tell me about that part. You said you verified with the city that it was okay. What did you do?
I brought to scale drawings.
These drawings that we.
Yes, sir.
In order to get the permit, gotcha.
Yes, sir.
I need to clarify something because the board's data sheet is not 100% correct. For a semi-detached structure, for an interior side yard, the setback is 15 feet. But that's only on the side yard that's open without the structure. On the side with the home on it that sits right on the property line, there's a 0 setback.
Yes.
So it's a 15-foot setback on just one side of the property. So the structure marked A does not require variance. Structure marked B is the one that's at issue. There's a 25-foot rear yard setback requirement that runs parallel with the rear property line. And that does not have an interior side yard setback. This structure is set 10 feet back from the rear property line and projects another 20 feet. So that means is only 5 foot of structure B sits in the interior side yard. The other 15 feet is in the rear yard, which this complies with. You can cover the rear yard up to 50% with accessory structures, and this complies with that provision. So really, the only issue that requires a variance is 5 foot of structure B.
And which leads me to my question, which is that I know you were explaining how the structures are secured with footers and
Yes, sir.
the difficulty that would be entailed in moving it. I was going to suggest that it seems to me that if you moved A and B together, so that it was one contiguous, well, it's not really one unit, but that they're
Looking
side
like
by
it's,
side,
yes, sir.
you would have no issue.
Functionally, that would be nearly impossible for me. I mean, it would be outside of my capability, financially or physically.
Okay.
Are you saying there's supposed to be 15 feet between the containers to the next property?
No. What we're saying is that here's, sir, what's your name?
James
James what?
Hawes, Haws.
Thank you. Okay, so this is the drawing of the property, okay? There's his house. This is the side property line, and that's the other side property line. The side property line which requires a setback is this one. Because on the side where the property or the dwelling units are adjoining, there's a 0 setback requirement from this property line. So it's only a setback for this property line. And this structure here, labeled B, projects into that setback. What I was saying was that if B was moved such that it was next to A, and they're side by side, they're at that point no longer within this side setback area, meaning that there's no need for any hearing on this matter. So what Mr. Tanner was explaining is that the only thing that we're really here on is the portion of whether or not to grant a variance for the portion of this storage unit which sits in this side yard setback area. That's the issue for the hearing. I can understand, as I was explaining, that many people may believe that shipping containers in the backyard are aesthetically unpleasant. When I asked before about whether or not there'd been any dialogue between the parties, that's a lot of the sort of general comments that I heard. But I just wanted to make sure that everyone knew that the aesthetics aren't something that we're here on. I may have my own thoughts about the aesthetics of a shipping container in the backyard, but that's not relevant to this case. The only thing that I am looking at in this case, and I'll assume that everyone else up here is as well, is whether or not to grant a variance for this projection into the interior side yard by whatever structure that's there.
I just have a question.
And your name is, ma'am?
Agnes Malloy. Agnes Malloy. I just have a question. So that means that every one of us that live up there, we could put a shipping container in behind our house. I know you can build a shed or a garage, but then that you have to go through people coming in inspecting it. It's made out of the right thing, but now we can just move in a shipping container.
building code enforcement is a different city agency, so I frankly wouldn't be able to opine as to the suitability under the building code of a shipping container. But for zoning purposes, yes, a structure is a structure is a structure. So
So that's what Baltimore City is going to be looking at, I
that's
guess.
not what I said.
Yeah.
That's not what I said at all.
Well,
What I said was that for zoning purposes, and what you have to understand is that when you build things, there are many different agencies of the city that have input there. There might be the planning department, might be zoning issues, building code enforcement, fire department. They all have their own areas of their own jurisdiction. Sometimes they overlap, sometimes they're independent of one another. So for our purposes, we just evaluate structures. Structures can take all different forms, and in this case, this involves a structure in this setback area.
Yeah, I
So
don't
we're
understand.
just
I don't
looking,
understand what you mean a setback.
okay,
Don't you have to
well,
have some
okay,
kind of
well,
room
just
between
a
it?
moment. You said you didn't understand what a setback was, I'll tell you. So there are different kinds of setbacks, and what the regulations are on setbacks is that, as the name implies, it means that whatever structure has to be set back from that boundary area by some distance. And the regulations for setbacks vary. Sometimes for a rear yard setback, that is how far any structure has to be set back from the rear property line, those vary. Side yard variance and side yard setback areas means that that any structure has to be set back from the side yard or the side yard boundary by a certain distance. What Mr. Tanner was pointing out was that for semi-detached dwellings, because there's already a structure that's built on that side of the property, because see how this is built right there into
Everything's
the
built
side?
on the property is a house.
Right. That's correct. This house is a structure.
Okay.
Okay. So there is a structure that is already built along the side of the property line. Okay. So the law says that for where there are semi-detached structures, that is, they connect on one side and they're not connected on the other, for semi-detached structures, on the side where the structures connect, there is a 0 setback because they're already connected on that side. Okay? So the setback requirement applies for the non-connected side. That is, only from this property line. This side property line is the one where there's a side setback requirement. There is no side setback requirement on the sides where the structures connect. So the setback area is the setback from this side property line back, I believe you said, was it 15 feet or 10 feet, Mr.
15.
15 feet from this side property line.
He won't have it.
That's why he's
Well,
here.
he's here for a variance. A variance is a request to vary that requirement. That is to permit a projection into that setback area.
It's within our jurisdiction to grant that.
I'm sorry.
It's within our jurisdiction to grant that, unless there's some compelling reason why we shouldn't.
So the neighborhood has nothing to say about it?
No, you can say that. If
It's a
you
historically
want to
registered area.
oppose, that's nice, but although I would point out that the historical registry isn't a zoning issue.
And that's come up 3 times.
Sorry. So whether an area is or isn't historic isn't really something that we consider. The planning department sometimes for historic areas and historic districts, there are requirements to go through a process for approvals for exterior modifications of structures within certain historic districts. Mr. French, is this one?
As was stated in the testimony, Brick Hill is a National Register Historic District, and the Commission for Historic and Architectural Preservation does not have jurisdiction over alterations, demolitions, or construction in those districts. They have to be locally designated districts in order for CHAP to have authority.
So, I guess here, the fact that you are on the National Registry works against you because it prevents local enforcement of the process that the city uses to evaluate modifications of historic structures in those historic areas.
I understand what you're saying.
Okay, so you said that you questioned whether or not the neighborhood has any input. The neighborhood, of course, has input. The neighborhood has input on the question of whether the criteria for a zoning variance have been met by this particular applicant. So that's sort of how we analyze this question. And that's the argument that we put forth by the opposition, that is to question whether or not the criteria has been met for a zoning variance. For the appellant, his burden is to show that the criteria have been met. There it is.
I think another issue is, if you could see it visually, that's a dead-end street, goes right into the hill of Druid Hill Park.
Mm-hmm.
So, having lost his backyard to vehicles, he is now parking them behind his, whatever they're called.
I'm
Which
parking
means
on-
that, other vehicles, only have so many feet to get past to their homes. So there are houses past him that are now impacted, twice as much. So, I don't know, it's so many issues here.
So they don't, is parking allowed in the
On the
alley?
side where he's at, no.
No, not on the
So
side.
that's a violation?
Well, it should be, yeah, except see, the hill is so old and the signs are so old, everybody.
The police would
Well-
enforce that.
I mean, I've been there 25 years, and this is the first problem we've had.
Well, I can understand that.
He parks his vehicle there, the trash truck can't get by.
Well, the issue there,
Is to
as
call
far as
311,
park-
no, yeah.
as far as parking goes, again, the board only has but so much authority and jurisdiction, and regulating off-street parking, well, we can to some extent, but largely we can't do anything about that. So if someone is improperly parking in the alley, sometimes people do it in the alley behind my house, for example, and then, when it happens, the neighbors all then have to complain to, as you said, ma'am, 311, to get someone out to write a ticket for illegal parking. But that's not a issue, or it's not one of the enumerated criteria for whether or not we can grant a variance.
How do you feel about the variance? You gonna grant it?
Well,
There's not that kind of space in between these two.
Excuse me.
Sir, folks, just so that we're, follow some bit of process. So I'd said before about how the proceedings are being recorded. So they're being recorded both on video, and they're also being recorded stenographically by this gentleman down here. And he's preparing a transcript. And in order to properly prepare that transcript, he needs to say, you know, that Mr. Hawes said X. And when people speak up out of turn, he can't write that down as unidentified male voice said. So please, if we can, if it's the first time that you've spoken, please identify yourself by saying your name, and then if he needs assistance in spelling it, he will ask you. And so that way we have the record reflected correctly. But your name, sir?
Malloy, Pat Malloy.
Okay. And M-A-L-L... Oh, M-O, okay. You had that? Okay, good. All right. So we would be voting at the end of the day. So that is once we get through the cases in the docket. And when we deliberate on the cases, we sit out here and do it. So we don't...
It just seems like every election, there's going to be all kind of transparency. No more behind closed meetings.
We don't have any here.
Well, there you go. It's
We sit
but it's-
right here.
You vote right here.
Yes, yes. We'll sit right here.
We get to stay. We get
You
to.
can stay.
You can stay if you want to, yes.
You discuss it all. You discuss what you're going to do.
Yep.
Yes.
And that's on TV too.
Yep.
What's that? Channel 725.
25.
So it'll be on tonight.
I can't tell you when.
What's it?
As far as the
2
schedule,
weeks?
the airing schedule goes, I'm not really sure of the airing schedule. It seems as though the hearings are on about sort of every other time when I flip past the channels. I do know that, at least for right now, the proceedings are being streamed live on the, I guess, on the internet site for the channel.
Okay.
Also, I think that there is a YouTube channel where you can call up each of the hearings as well.
Well, the
Who
man,
wants them whenever.
the man came in, the owner of the property came in and did a nice job in the front. You know, fixed it all up. The inside, he had pictures of it on the internet. Was all done real nice and landscaped and everything. And then all of a sudden, in the dead of the night, out of the clear blue, with no going around like other people when they do things that are going before the zoning, they come around to the neighbors and say, look, I'm going to do this, that, or the other. Is that going to be okay with you or not? If it's not, before I spend all this money, how about letting me know if you're going to like this or not, so we don't wind up, I spend, what'd you spend, like $5,000 on this so far? On these containers? How much do they cost? I'm sure they're not cheap. Anyway, before I spend all this money, let me know one way or the other, what do you think about this? I mean, if you don't like the containers, if you don't think they're going to fit in the neighborhood, then I'll do what normal people do. I'll put a shed back there, or I'll put a garage back there. Let me know up front, instead of all this coming down here, wasting all these people taking time off of work, have to come down here and sit for 3 hours, and then it's just, we find out that if we don't like it, it's tough. It's not, aesthetics doesn't play into it. But I'm sure if it was Guilford or Roland Park, aesthetics would play into it. So here we are out left in the cold, and all the junk gets put in, Hamden, Medfield, and Woodbury, and we have to come down here and fight, and then or we can appeal it, and then which we've done on the billboard issues, going all the way down to Annapolis, and still lost. And now we're listening to accidents, every other day on the 83. And not to get off the subject, but I'm just saying it seems like the process needs to be updated a little bit, so the community, the people living there, like me, and Mr. Hawes here, that's put $40,000 or $50,000, $60,000 in their home to make it look nice, doesn't have to look at a rusty shipping container in the back of the yard. I mean, there should be some respect here, and there's not any respect.
If I understood the applicant correctly, I think that there are a number of things that he would have done differently in retrospect if he thought this through a little bit more. And certainly if he had envisioned things going as they have. but that's water under the bridge. One thing I will point out is, though, that to this point, and we've been really far down in this hearing, and we've gone way longer than we should have. But at this point, neither side really has addressed any of the factors for a variance. And I think that that's likely because the applicant is sort of just as with the decision to go forward with the shipping containers, doesn't really know the process and hasn't really taken the time to figure that part out. And the community has been understandably upset over the sight of shipping containers and has really focused their attention on that, but really hasn't taken the time either to find out what the process is. And so we've been here for about, probably I'm guessing, at least half an hour, probably closer to 40 to 45 minutes, and no one has talked about any of the relevant issues in the case.
I'd like to say one thing. He said it. He said that he was put out of his storage container and he had to move quickly somewhere. And that's why he got the shipping containers. He didn't consider a shed or a garage or anything else.
That's not, my name's John Frankel. That's not what I said.
Yes, it is what you said.
Okay. Just so that we're all on the same page. So, ma'am, yes.
Janice Adelhart. Hi there. He had
Janice.
Adelhart, Adelhardt. He had an inspector come out for every single part of him attempting to put this together, including the flitters. I mean, every step of the way. If that was the case of a variance, which we didn't know about, why didn't the inspector tell us in advance? Why were we approved for each step of the inspection?
I can't really tell you anything about that. Frankly, I have no idea.
Because we were.
Well, I'm not questioning that. I'm not questioning that, ma'am.
Okay.
And I think that like you would see with any large organization, I think the city of Baltimore is something like 14,000 employees or something like that. And I think as you would see in any kind of organization, there are people of varying levels of competence within any organization, and sometimes you find people with less competence than others, and you might have had the unfortunate pleasure of having one with less competence than would be otherwise expected. But I can't really speak to that end of the process. The only thing I can say is that there's a requirement for a interior yard setback with your property. And you've got these structures that are located in the setback area, and either A, have to be moved, or B, you need to be granted a variance. The standard for variances are found in Chapter 15 of the zoning code. I guess it's Article 15, and it's in the 200s. And so it starts with 15 to 17. In general, a variance may not be granted unless after public notice and a hearing, the board or the mayor and city council, as the case may be, makes the following findings. Then you move on to 15 to 18. Finding of unnecessary hardship or practical difficulty. The board and mayor city council must find that because of the particular physical surroundings, shape, or topographical conditions of the specific structure or land involved, an unnecessary hardship or practical difficulty would result, as distinguished from a mere inconvenience if the strict letter of the applicable requirement were carried out. Then you move on to 15 to 19. Other required findings. The board or mayor and city council must also find that, 1, conditions on which the application is based are unique to the property for which the variance is sought and are not generally applicable to other property within the same zoning classification. 2, the unnecessary hardship or practical difficulty is caused by this article and has not been created by the intentional action or inaction of any person who has a present interest in the property. 3, the purpose of the variance is not based exclusively on a desire to increase the value or income potential of the property. 4, the variance will not either 1, be injurious to the use and enjoyment of other property in the immediate vicinity, or 2, substantially diminish and impair property values in the neighborhood. 5 lists a bunch of other things that we have to find as far as what the variance will not do. So those are the issues that we have to evaluate.
Is it okay if I add one thing? I've spoken at length, both neighbors on both sides, I've spoken at length with them, and what works for them. You know, very willing to do everything I can, you know, to make it so that it's not an issue, and hopefully at some point it'll be a positive thing, you know, a nice mural or a nice something, whatever it takes. Now, I mean, to the extent that we've talked about skirts on, you know, under it, and at what stage we'll paint one side that will be covered with a fence for the gentleman Kevin that's building the house, you know, same duplex. And so I've spent a lot of time talking with the neighbors on both sides about, you know, what works for them, and in this way they're not here, you know, for a reason.
Okay.
I'm not sensitive to, regardless of the legal reasons. I'm not sensitive to. They live here also, but things like this morning can't happen.
Okay. Again, I can't really talk about things that didn't happen here or what have you, and I certainly did appreciate from your initial presentation the fact that you had been working and consulting your immediate neighbors to try to get something worked out with them. But you'll also note that as I read off those various different things that we have to find, one of the things that it does not say that we have to find is that the applicant consulted with their neighbors. So that it's certainly a consideration that goes towards, you know, your candor and the desire that you've had here to try to work things out, but it's not something that's determinative of the question of the variance one way or the other.
Thank you.
All right, so we're going to wrap this up. Did you have anything to say as to any
No,
closing
thank you for your
remarks?
time, sir.
Okay.
Ma'am.
All right. All right. Thank you, folks. 2016-100, 3104 North Hilton Street. Lisa Junker. Good afternoon, Ms. Junker. How are you?
Fine, thanks. How are you?
Thank you. We have this as an application to use the premises to house 2 dwelling units as a multiple-family detached dwelling at this location. Is that correct?
That is correct.
Okay. And all those giving testimony raise their hands and be sworn, please.
Will you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, and I know this is a pickup from prior hearing, but we have staff reports.
Yes, attached with the staff report are 9 additional photographs that were not available at the last hearing. We have a letter from the Forest Park Neighborhood Association, from their president, Sharon Bradford. This letter is to state that the Forest Park Neighborhood Association does not oppose the zoning board's recommendation and recommends that the 2 dwelling units for 3104 North Hilton Street be approved. That's all I have.
Okay. And Mr. French, was there anything from the planning department?
Planning Department reviewed the application, noted the property is contained in an R4 zoning district in which conversion of single-family dwelling units to multiple-family dwelling units is not authorized. The property's last use apparently was as a single-family dwelling, according to the information available to this department. The department therefore recommends disapproval of the appeal because the board is not authorized to approve conversion of a 1-family dwelling to a 2-family dwelling unit in an R4 zoning district where this property is located. Thank you.
Thank you. Okay. Ms. Junker.
Yes, some of the information I had from the initial presentation is actually in the file that I no longer have in my records. So I'm going to be referring to information that's already been previously submitted, but not at the original time of application. So we are here today because what we would like to do is actually not convert a single-family building, a single-family dwelling. We would like to revert back to its original built, created, and use of a building that, once you review the pictures, you'll see is actually in aesthetic alignment with the community. And I'd like to present a single caveat that is really very relevant to this, besides the fact that, again, we're not converting an only ever been single-family dwelling into suddenly a new two-dwelling unit building. We are reverting a building that, according to the records, was last used as a single-family dwelling, but we're actually trying to revert it back to its original historical designed use of two dwelling units. And it had been used as a two dwelling unit building at the time of purchase, but the records weren't checked and collaborated and what have you, so the records and the use at the time of acquisition aren't consistent. Also, like was read onto record, Forest Park Neighborhood Association was presented with the owner's intention to actually legally put onto record its use when she had acquired the building to what she would like the records to read, and their letter shows that Forest Park Neighborhood Association does not oppose it going back to the two dwelling units, being used as the two dwelling units, what have you. And this is important for my next comment. There's a component for the zoning code of Baltimore City that includes intent, and this provision that is the basis of the planning department to not support it is actually in conflict with an allowable use in the R4 zoning district. And given the fact that this building had a fire, and we're going to be getting to all these specifics in order, if the building was determined to be not structurally sound, and therefore the insurance company would pay for the demolition of this building in its entirety, the property owner could actually go and build a two dwelling unit house. It is permitted in an R4 district, provided that all other conditions are met, but a two dwelling unit, new construction, detached, is permitted by right in an R4 zoning district, which is almost in complete conflict with the restriction that prevents this building, which is pretty much the basis of why we're here, that's preventing this building from being reverted back to, purely because it's existing. And that is the only impediment to what the board is perceiving as its legal authority to grant this request. Now, I'm going after this under the no better use provision because the uniqueness factor tied to this property is it's the largest lot. It is double most of the other lots in the district. I'm not sure if I still have the property plat. It is larger than its two neighboring properties, and it's almost double all the other, my plat map was submitted originally.
Contains 17,000 square feet.
Yeah, and the properties that exist around it are less than half that. There are two others that are larger than most of them, but this property exceeds the lot size of every other surrounding property. Also, the house is too large to operate as a single-family dwelling. I hate to put it to you this way, but, not I hate to put it to you this way, what I hate to actually admit, since it's not allowed to be used right now because of the fire condition, is it was always used as a multifamily dwelling since this person acquired it. And I can't speak to the gap on the records of zoning enforcement summary that shows that decades ago, it had gone from two dwelling units down to a single-family dwelling, but somewhere along the line, the single-family dwelling went back to being a multifamily dwelling. There are two gas meters that have been servicing this building. There's a photo of that in the records as well that I submitted the last time that I presented to the board, but not at the time of the application. So all the data is showing, whether it's been according to the zoning enforcement department, whether it's been legitimized with the certificate of occupancy, it has been functioning and operating as a two dwelling unit. The no better use clause, if it was approved, would not trigger any other or exacerbate any other zoning variances. So again, going to the allowance of the two dwelling units for a building that, as you saw historically, would be in conflict with the design and nature of the character if it was torn down and rebuilt as a two dwelling unit would not be to the harmony of the community. And that's pretty much the basis of it. I mean, that's really the essence of what I'm saying. I'm not looking to convert, I'm looking to revert. To tear it down and rebuild, we would be entitled by right to become a two-dwelling unit as a permitted use detached in the R4 district. To build now with current modern-day materials, it would not be characteristic of the community, of the other surrounding types of historical properties that are right around it. And the nature and the character and the scope of the house that is fire damaged, the two dwelling units under the fire rebuild would actually permit the property owner to be able to restore the house to its original character, design, and usage. The uniqueness is the lot size. It's not triggering any additional zoning variances, and we're not looking to convert, we're looking to revert. And that, in essence, is the basis of why we're here today.
When you say that you're not looking to convert, you're looking to revert.
It historically was built as a two-dwelling unit property, residence structure.
And as I'm recalling it, there was, I guess, a prior owner who
Yes, historically, it shows on the
used
record.
it down to
Yes, back in the
single
30s.
family.
But somewhere between the 30s and when she bought it, it had
the
been.
current owner?
She being the current owner, it had been utilized and operating as a two-dwelling unit. And quite honestly, it was being operated as a multifamily dwelling because it wasn't until the fire happened that all this came out when going through the whole redesign and getting ready to do the permits. And Brad Lamont contacted me that all this kind of presented itself, and it was identified that it was a single-family dwelling per record.
And you said it was operated as a multifamily. Was that a three or more unit?
No, I mean two.
Okay.
To me, you're right, more than two is multifamily, but no, two dwelling units.
But-
There's 2 meters.
It's multiple family, but does not require a license.
Permit, yeah, right,
if it's
license,
less
right.
than 3.
Okay, thanks. So the 2 gas meters were on existence of the building. I can show that the initial historical purpose of the building was originally as a 2-dwelling unit. The setup was as more than 1 dwelling unit. And like I said, if the non-supported expenses were put in to demolish the building and it was rebuilt as a new single-family detached dwelling, it would be permitted by right because it would trigger no other variances or needs for consideration. It could be a 2-dwelling unit. And I know that the community would not want, I don't know if you guys are familiar with what's being built on Lake Avenue, and I hope I'm not stepping on my own feet, but if you've seen the house that's being built on Lake Avenue, on Roland, approaching Lake, it is completely out of character with the entire neighborhood. It's all, do you know what I'm talking about?
do, actually.
Okay,
I live across the street from there.
So, it's out of character with what is being built and what is in existence. And economically speaking, it's not an income-generating perspective. It is actually an economic basis for this. It would be cheaper for her to restore this house and to be able to have the second unit placed back into it. But if she's forced to do it, in order to get the money out of it, it's almost cheaper to demolish this house and rebuild something smaller and get the second dwelling unit, build it back in, and then it's out of character. And there's nothing anybody can do, and it would be in conflict with the community. So the basis that I'm asking for this is no better use clause because the alternative is not characteristic.
Okay. Is this a, can't recall, Mr. French, did you say whether or not this is in a historic district?
No, this is not in an historic district.
And I'm not saying that it is in historic districts, I'm just saying architecturally it'd be in conflict with the surrounding character of its existing homes. I mean, these are neighboring properties, so clearly anything new would be in direct conflict with the architectural integrity and character of the community.
The house itself is
That's
rather
this one.
attractive, and the other houses there are all
No, they're all,
stately homes.
they all are stately homes.
But, you know, as I told the folks in the case before you, aesthetics really isn't something that we've got jurisdiction to consider.
No, but the point is that if the reversion isn't considered, we're not asking you to put aesthetics into consideration. We're asking for a decision that doesn't cause any conflict or harm to the community, but the alternative of tearing this down to build a by right two-dwelling unit building would be an issue to this community. And so just because you can doesn't mean you should. So by virtue of them not being able to revert the home back to its original historical designed use, the only alternative for them to be, if their intent on going forward is to tear down this architectural gem and build a new, less preferable dwelling unit by right to allow for the two dwelling units, which they are allowed to have if it's new. That's where the code and the conflict in this code is. By right, if they tore down this gem and they built crap, they could have two dwelling units. But if they preserve this architectural gem, they're restricted from its original historical designed use. And really,
Historical designed use, but the of record use when the owner bought it.
the existing use when the owner bought it was this two dwelling units. The record of use in Baltimore State, well, most people don't go and research the zoning history of a property when they buy it, so ignorance is no excuse. I get it from an attorney standpoint, I get it from a zoning standpoint, but the common denominator is most people, when they get a realtor listing, don't know to go and verify the fact whether the house was on the zoning records, especially since the whole zoning process didn't really regroup until like 2002, 3, 4. A lot of stuff was getting through without verification. From an inspection standpoint, from an administrative standpoint, a lot of things weren't being as highlighted and closely coordinated as they have been in the last 10 to 15 years. And a lot of things went through and weren't properly verified. And now, going forward, from a title standpoint, a lot of things wouldn't get to settlement without the verification. But, you know, at the time, there's nothing you can do. The house historically was a two-dwelling unit building. Nobody's contesting that. Nobody's contesting the fact that historically, at some point, somebody changed on the record. And actually, when things were changed on the record historically, they weren't actively changed. They were actually changed by virtue of inspections and observances. So things didn't always go through the administrative process to get from one documented use to a second documented use. They used to be records that were updated. So there wasn't, that's what I'm talking about. So if you could see, the original documentation shows the two dwelling units, and then in, I think, 1931, it went down to a single-family dwelling. And then there's no other history on the records.
In 1931, it says 2 apartments.
Okay.
And then in 1945, it says
sorry.
1-family dwelling. Doesn't say anything about permits being issued.
That's what I'm saying. It's observed from an inspection standpoint. Nobody woefully went and made a change. We don't know the basis of the updating of that record. And then there's been nothing since then. Is there SDAT in the records? Because I don't seem to have my SDAT.
Yeah.
Would you mind?
Thank you. Oh, thanks.
I don't think they're helpful.
The house, the structure was built in 1920. So that is what the records show, that in 1920, the structure was built, and up until 1945, from 1931 on, I can't speak to what was done in 1920, but the original documented use was 2 dwelling units. If you look at, you see the structure built right here? Okay.
The zoning record started with the police survey of 1931.
So, okay.
So,
No, 1931 was 2 dwelling
It
units.
said 2 apartments.
So it was recognized as a 2, well,
Hold it. When I looked at
survey
the,
says dwelling and garages.
yes, dwelling,
And then
not plural.
same year.
And the
it
same
says
year, the 2 was
dwelling.
authorized, but that was after the police survey.
But we weren't there then, so.
All right. Any questions?
no.
Thank you.
Thank you.
Whatever time we finish here. 2 more hearings to hear first.
Yes. 2016-112, 2053 East Monument Street, Michael Collins.
Afternoon, gentlemen. How are you? Ladies.
Can I ask, please, I parked my car in the wrong spot. I didn't realize I don't take this long. May I run and move it, please?
Well, yes, we're probably not going to get to you in the next 10 minutes, so.
Awesome,
please.
thank you very much. Thank you.
Good afternoon. My name is Michael Collins, and
Okay, and Mr. Collins, we have this as an application to add the outdoor display of merchandise for sale to the public as accessory to the existing first-floor novelty store within a mixed-use, multiple-family attached dwelling. Is that correct?
that's correct.
Okay. All those intending to give testimony, raise their right hands, be sworn, please.
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay, do we have staff reports?
I have nothing.
Thank you. Planning Department reviewed this application, noted this property is in a B2 zone. It is also in the Middle East Urban Renewal Plan area. That urban renewal plan designates this property as part of the East Monument Street business area. In that context, the urban renewal plan states explicitly, display of goods shall be restricted to the inside of store premises with the exception of special sales events sponsored by the East Monument Street Merchants Association and with the permission of the Department of Housing and Community Development. On that basis, the plan would prevent the board from approving this appeal other than with that condition and limitation stated in the plan. For that reason, the Department of Planning recommends approval only if it is subject to the condition and limitation stated in the Middle East Urban Renewal Plan concerning outdoor display of goods or merchandise. Thank you.
Thank you. Okay, Mr. Collins, just to kind of translate a little bit, you're here requesting to display merchandise outside your store.
Yes, I am.
What Mr. French is saying is that the area that you are in is an urban renewal area. It means it's covered by a urban renewal ordinance, which applies to various different uses of property and prescribes different rules, which are in addition to those found in the zoning code, and which limit what we can do. And what that ordinance says is that you cannot have merchandise displayed outside your store. Any store cannot have merchandise displayed outside of it unless it's part of some special sale or promotion or something like that. And then, so yeah, I guess they sort of they envision that maybe you can do it every once in a while. Memorial Day is coming. Maybe you're having a Memorial Day sale. You want to display things outside. You can do it for that kind of limited, very short duration occasion, but you cannot do it as a regular occurrence. And that's what you're asking us for. We have to yield to what the urban renewal ordinance says, unless you've got some other authority or other basis by which we can not follow the urban renewal ordinance.
Really, I don't have anything else to add to it, what you said already, and so just have to go along with y'all agree to at this particular point. I mean, my business, the East Baltimore business has changed considerably over the years, and it caused me necessary to have to come out in the front to present my sales, because being inside, since I have a small store, and the area has changed considerably, it makes it harder and harder. And I'm just a small businessman trying to survive and make a living for myself. But we not only provide for
Who's your council person, by the way?
Young.
Okay. Well,
Young,
no,
he's the president now, right? I can't recall.
Leave it be.
Branch, okay. Yeah.
Although I believe he just lost in the election.
That is correct.
Yeah.
Assuming, well.
That has got to be updated, I guess, basically.
He actually gets certified.
Sure. Yes. I was going to suggest that, it's an urban renewal ordinance, and is there any information, Mr. French, as to when that was passed?
No, but the urban renewal plan is something that certainly dates back to the 1980s, if not earlier, to the 1970s.
And what I was going to suggest is that, I was looking at the photographs which we have showing the exterior of your store. You sell DVDs, I guess, correct?
Definitely.
And I know that the way that people consume media now, particularly films and the like, has changed, and it can be rather challenging in that environment to sell DVDs if you're just simply limited to the interior area of your store. And I'm going to imagine that probably applies for a number of the different merchants there as well, who are in other areas, just as a general reflection of the overall economic condition of that commercial area there. And so it might be more fruitful to approach I don't know if there's a businessmen's association or association of businesses in that area, but to approach the council person for the area and say that, I think that it's time that the urban renewal ordinance be updated, and so that way they can pass an ordinance to change the limitation that's there, so that you can be allowed to do this kind of thing. But I guess at least as it stands right now, you're permitted to have certain periodic sales and have outdoor display of merchandise associated with those particular promotional times or offers. But otherwise, you wouldn't be able to do it.
Okay.
So, okay. Thank you very much.
Thank you very much.
Thank you. Thank you, sir.
Yeah.
All right. And since the next case, the gentleman had to go to move his car, we will take a 5-minute break. Go on.
Somebody's got to get
No, but I'm parked over by under 83.
I know you, boy.
No, I won't be towed because I've been here since 11:30.
Calling 1448 North Mount Street. Chukwumeka Egwu.
I am here.
Okay. And sir, we have this as an application to use the first floor front as a pizza shop, first floor rear as a barber shop, second floor as a hair salon, and third floor as offices. Is that correct?
Actually, you have that reverse. It's first floor front as a barber shop, rear as a pizza shop.
Okay.
Then top floor as a hair salon.
All right. Why don't all those intending to give testimony raise their right hands and be sworn?
Do you swear or affirm the testimony that you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
I do.
Mr. Chair, for the record, I'll recuse myself from this appeal.
Okay. All right. Do we have staff reports?
Yes, we have a letter from the Fulton Community Association and Western District CRC. They write that they do not support the use of 1448 North Mount Street for the above businesses, and that the building, due to the following reasons. The building does not have windows in the front. The building is in a residential block. The community does not need another fast food establishment in the community. It's a store and a fast food restaurant. There is a store and a fast food restaurant across the street from the building on the Baker Street side. That is too many businesses in one building. Young people already hang out on one side of that building, and across the street at a store and a restaurant. I talked to the appellant and suggested that he look for a building in a business area like North Avenue that has windows, was a business before. He has not come to the community meeting. He does not live in the community. The community wants and needs a supermarket. That the building should be used only for dwelling units. And then we have planning's report.
Thank you. Planning Department reviewed the application, noted that the use of the property as a non-conforming use was last authorized as a dry cleaning establishment and a beauty shop, and of course a single-family attached dwelling, a permitted use. The board is authorized to approve the change of non-conforming use to restaurant pizza shop, but a carryout pizza shop would not be permitted as it is not listed in the B1 section of the zoning code. There is, however, another issue, which is the Sandtown Winchester Urban Renewal Plan. This property is located in the Sandtown Winchester Urban Renewal Area, and the plan states directly, no non-complying land use shall be changed to any other non-complying land use, which is urban renewal speak for non-conforming use shall be changed to another non-conforming use. This property is designated in that plan as residential, and therefore makes any commercial use of the property a non-complying use, as the term is used in that urban renewal plan. The department therefore recommends disapproval of this application because the urban renewal plan for the area in which the property is located prohibits changing an existing non-conforming land use to any other non-conforming land use. On that basis, obviously, the only uses that could be made of the property commercially would be a dry cleaning establishment and a beauty shop. Thank you.
Thank you. Okay, Mr. Egwu, I assume the easiest place to begin is with what Mr. French just stated, the limitations imposed by the urban renewal plan. I don't know if you were prepared to address that or not, but I think that we need to start there.
I am. My name is Chukwemeka Egu, for the record. I responded to the memo by the planning board a little flustered, I would say, so forgive me for the harsh word, but the point I made there still remain intact. When I read through the urban renewal, new urban renewal that he cited, what I found that if you go through back and study hard, you notice that starting from 1990, so actually from 1983 on forward, they went into effect for the urban renewal plan, which put about $130 million into the Sandtown Winchester neighborhood. I have been in that block right now for about 3 months. I live in the neighborhood. I live in the same zip code. And actually, I do hear about Sandtown Winchester a lot on the radio. Each time I hear about it, is all the problem happening in Sandtown Winchester, blaming everybody that lives in Sandtown Winchester for the problem. Just from my overview, the problem happening in Sandtown Winchester is actually subjective, not circumstantial. For this reason, I'll tell you a personal story. In 1990, I came to this country with my best friend. The person was supposed to live to run into some problem. We couldn't even stay with him quite well, so we're pretty much homeless. My friend moved up to upstate New York. I stayed in Washington, D.C., which is way worse than Baltimore today in 1990. This is my life experience. I'm about to starve to death, coming home one day from playing basketball. That's about the only thing I can do, plus hanging out and staying with somebody's couch. I was starving, literally. Somebody gave me $1 at the basketball court. I was walking home, about to pass out from hunger. I saw a sign, slice of pizza, $1. You know what? I'm like, I can afford it. I have $1. So I walked in there and asked for a slice of pizza. When the man rang it up, he said $1.05. Where did 5 cents come from? I found out you had to pay Uncle Sam. And I told him I only had $1. The man took a look at me and says, you know what? If you don't have $1.05, I have 4 boxes of pizza. Going 4 blocks that way, my drivers are playing games with me today. None of them is all of them are taking their time. If you can walk it that 4 blocks, I'll give you $5. Of course, I said yes. I took those boxes and walked it 4 blocks, delivered it, $41.60. I remember that money till date. The guy gave me $50. I came back and handed him $50. He turned around and gives me $8 on some change. Said, that's your tip. I never knew you could earn a tip. Then he also gave me the $5. He promised me. All of a sudden, I had $13 and change in my pocket. When I say this to you, that's what neighborhood business does for people. You have to have that first opportunity. On that day, if I had any other option to do anything, sell drugs, do something for food, I would have done it. So going to Sandtown Winchester, this is my opportunity to give back, because 8 years from that day, I ended up working for this guy for about 2 years, delivering pizza, anything he could do, restaurant management, anything he wanted, I was all man out. 8 years from that day, I opened up my own restaurant on U Street, 1300 block. Now the hottest block in America. Again, this was the block that was, you and I could not go there after 6 p.m. That's how bad U Street was. So we say Baltimore's bad. Baltimore has a lot of opportunities. I opened my own restaurant.
I lived in the District of Columbia around that time.
So you know what I'm talking about. So you saw U Street crawl back, and today, if you go back to U Street, every place is shut, businesses, and everything else. So the problem I'm having here is my friend ended up getting into some trouble, getting deported 3 years later. He went back home because he got into some trouble. Look at me. I survived because somebody gave me a shot. When we look at what's happening on the street today, who's giving these kids a shot? As a young man, you need that startup job. Most often, the person will give it to you, somebody who just took pity on you, just know you, and say, come sweep the floor. You learn how to make honest money. When we deny kids that, what are we really saying? Get out of the street, don't do crime, but you have no other option. You don't even know how to start to learn how to walk. That's why I was flustered when I got that memo, because Baltimore needs job. What I am proposing is a pizza shop that will employ 6 people. I know how to cook. I'm a great chef, but I'm not going to run it. I'm a little older now, but I know how to run business. People, kids in the neighborhood. When I was buying this property at auction, I was the only person that showed up to buy it. The kids were hanging out. You thought it was going to be a mob, and I was a little scared myself. I'm a big guy. But at the end, they walked up to me and said, oh, you bought that property. What are you going to do with it? I'm like, guys, what do you want with it? They actually suggested what they wanted. We want a barber shop. Somebody wanted a music studio. I'm like, we cannot do that. They wanted a hair salon. And somebody said, we'd like to have a carry-out nearby. They suggested, the kids on the street suggested this to me. And today when I go back there, they tell me, oh, you know what, we got to be looking out for you. Don't break into it, I told them. So these are all what the kids want. I know I've talked to ma'am here extensively. It breaks my heart that the need for job in Baltimore inner city is not being addressed. The government can do everything they want, but the people that actually change the city and change the inner city is you and I who are willing to invest in this neighborhood and actually present an example that are actually alternatives to what is happening. For me, standing here before you, I've had 3 or 4 businesses before that. If I knew what I know now today, I would own the entire block of U Street, which I had the opportunity when I was younger. Instead of spending my money that I made wisely, I ended up getting a club, I partied, but I could grow wise, I had no regrets. But the building I had my restaurant in today in U Street, which my landlord bought way back then for like $90,000, you can't even touch it for $1.5 million today. That's the opportunity we have in Baltimore. But for you to change it, you cannot change it as government entity. I'm sorry. You need people who are going to invest in the neighborhood, encourage people to come back, elevate the property value of that neighborhood. We're talking about one building. This building has been nothing but commercial for 80 years, nothing else. Since 1936, this building has been they sell firewood, they sell lunchroom, they do dry cleaning. They've done everything, restaurant and all, since 1936. So what I'm actually doing is upholding the historic value of this building. I'm not changing the structure. I'm just implementing back into this building, the business that had been there over time. In doing that, we're going to create 4 barbing stations. For kids, this is an entrepreneurial job. Just like I had an opportunity way back, a kid that comes there to get his hair cut, learns how to cut hair, may end up opening up a shop down the street. That's what we need for kids to grow. The beauty salon, I met a young lady, she's probably 17, the most smartest, beautiful person you can have meet from the street there. What do you want to do here? I'm like, a hair salon. She was so excited. I'm like, when it's ready, come walk with me. She's excited. Go to Sanchong, we don't have a hair salon. We barely don't have a barber shop. We have a couple of fast food, but you know what? The businesses you're looking at, you're talking about in comparison to what I'm doing, I am doing the entire building. It's going to cost me almost $200,000 of my own money to do this. The mistake we're making in rehabbing our neighborhood is when people come, we want them just to put a business in a small, tiny section of a building and leave the whole building undeveloped. That's bad for the neighborhood. That kind of business I am utmostly against, because it makes the neighborhood look bad. Because when you stand, the whole structure is falling apart, only about 25% of that building is being used. It doesn't help the neighborhood, it doesn't uplift the value at all. So please, standing before you, you have the power to grant this variance, I know that. If you talk about making a restaurant, sure, I can confirm, make it You don't?
No.
Who does? I'm sorry, I have to ask. Well, you know how that's what we're here.
What your issue is the same as the issue, at least one of your issues is the same as the issue was in the case before you, which is that there's an urban renewal ordinance that's in effect that says that one
conforming use cannot be conforming use. I've read it 10 times, but may I interject?
And the board is bound by that. So if you wanted to change it, I would suggest the first place you would want to go is to the council person in that area, who I believe
It's Pete Welsh.
Mr. Mosby, I believe.
Well, Welsh is above that.
Well,
by Lawrence Street, yeah.
Yeah, but the point is, there's a new one who was just elected, and that would be the first place to start in order to get that changed. But unless and until that happens, all that I can tell you is that the board has to respect the provisions of the urban renewal ordinance. And if the planning department is in their jurisdiction to enforce urban renewal ordinances, and if their position is what is being asked of you, you can't do because there's this other law that says you can't do it, we have to respect that. I said, unless you're aware of some other authority, or unless we've had cases where we've gone down and looked to see if this property actually is in the urban renewal area or not. But if that's not an issue, and everyone agrees that it is in the urban renewal area, and the urban renewal ordinance does in fact say what it says, because we've had other cases where there's been some question about that. But if it is in the urban renewal area, and the urban renewal ordinance does say what the planning department says, that it says, then we have to yield to that.
Well, we have mitigating circumstances in this case, which are very serious, because right now, attempt to insure that building, you cannot, because try to insure that it's a single-family dwelling, it is not. When insurance come by and look at it, sorry, it's not a single-family dwelling. Try to insure it as a commercial building. They will not insure it because guess what? It's zoned as a single-family dwelling. And that problem that adds to that building is probably the biggest in the whole block. It covers the whole property. So it's about over 3,000 square feet if you combine it. If you make that into a single-family dwelling, it's going to cost you at least minimum $300,000. How no bank will touch that. Nobody will invest that money in that neighborhood. The question I do have for the committee, which again, if we're in planning, and planning for a sustainable and viable community, what do you suggest to do that with that building? Because there's no financial entity that's viable at this point. What we've ended up creating is what is called an impracticable scheme. And you cannot subject anyone in any community to that.
Sure, and I think that what you've kind of put your finger on is the fact that much in a case, I think that was 2 cases before yours, the provisions of the various different laws may not always lead to, frankly, common sense outcomes. But the board is a board of limited jurisdiction. All that we can do is respect whatever laws are passed by the city council and are signed by the mayor. And I may well agree with you that what may be holding back areas such as Sandtown, Winchester, are too many rules, and that maybe the answer is to have a lot fewer, so that market forces can come in and have the effect that they did in areas like U Street, and let capital do what it does. But I am not on the city council, and I am not the mayor. So that's not my decision to make.
So you're telling me, standing before you, that this board has no power at all to do anything for the situation I find myself with this building, even to the fact that...
As far as the request that you've made, that is correct.
What am I allowed to use the building for?
I would say the first place, if you're not going to start with the councilman's office, and I can understand why you might want to hold off on that because you're getting a new council person, although they won't be seated until December. The place I would suggest that you start is with the planning department to find out what the urban renewal ordinance provides and what you can do. And there's probably a neighborhood planner who works in this area who likely has some very good ideas about how you can utilize your property within the bounds of the urban renewal ordinance. Mr. French.
Correct. The planning department would encourage you to work with the community planner, in this case, in the Western Planning District, which is Chad Hayes, and also with the neighborhood association, because obviously the elected representative, if he is going to introduce a bill to amend the urban renewal ordinance or even to repeal it entirely, is going to want to know that there will be support for that coming from the community. So we would encourage you to reach out that way as well.
Frankly, may I speak? I mean, I've been speaking quite my mind. May I add? I mean, it sounds like everybody doesn't even hear what I'm saying. I'm sorry, please. You cannot get insurance for this building as it stands right now. There's no liability to that building. I cannot. I've tried. Every insurance company has turned me down because the way this is zoned. That's something that needs to be fixed like now. Because if I don't have insurance for the building, what if somebody gets hurt in the building? What if the building crumbles and kills somebody? What's going to happen then? That is something we can be able to fix. Like it has to be fixed now.
That's correct.
We can't fix it for you.
Yes. One thing I would also point out is many a person's grandmother has likely brought up the phrase that haste makes waste. And the point of that is that by acting quickly, we can get ourselves into situations that waste a lot of things, time, money, things like that. A lot of times it can be expedient to make decisions and hastily, without sort of fully investigating the ramifications of what we're doing. There was another case today that was the central point. But the thing that I would also urge you to do after contacting the district planner is just make sure that whatever it is you decide to do it in a way where you do your due diligence beforehand so that you don't find yourself in this situation.
Please, I have another
Here, you purchase the property without fully considering or looking at
I am
all
good at
the
this. Your Honor, I don't know if it's just you as a judge, but I'm sorry. Your Honor, I am good at this, honestly. I'll tell you honestly. I am very good at viewing priority and seeing the potential. I know from firsthand the problem we have in Sandtown is one that breaks my heart because I could have very, very much been one of those kids standing on the street today, probably have never been here standing before you. I have a problem about Mr. Bob also kind of recusing yourself from this area. I can understand that concept because if anything, we want to hear your opinion as a developer, what kind of financial constraints you find yourself or liability or problems you find yourself hanging onto a property that cannot be either A nor B. That's an impossible situation. And if the city cannot address that, a building just fell and killed somebody.
I'd say that Mr. Barb recused himself because his knowledge of the issues at play in the case feels that he cannot be fair and impartial to one or both sides. So he recused himself so that there cannot be any suggestion by any party that he was conflicted. So I think that's to the benefit of the parties.
You guys have me on the spot. I mean, because this is a liability issue that I cannot carry on my own because I think the city has to be liable for the fact that a building is within a city district that you cannot insure because the way the city has it classified. And you're creating a burden on someone because I don't think the city can even make this building a one single family dwelling. The city cannot. The city can fund it and make it into a single family building. I'll gladly sell it to them.
Was, as I've said, and as Mr. French said, that there are likely a number of uses that could be made of the property under the urban renewal ordinance, and if you start with the district planner and the community association and you work with them to find out what those potential uses are and what uses the community would support, then that would go a long way in addressing your current situation. But this board, because of the urban renewal ordinance, can't give you what you're asking for.
Well, the urban renewal ordinance has not worked. It has not worked.
That may be a very valid point, but that's not something that's going to change unless, as I also suggested, you approach the council person about your ideas on changing it. They, as Mr. Friend said, would probably also ask that you go to the community association because any change that you're asking for, the council person would want there to be neighborhood support for.
I have done that. I spoke to Ms. Robs extensively because I tried to find out the initial time I acquired this building. I went to the police station. I tried so hard. I even spoke to a neighbor on the same street. Mercy. She gave me a number that I called and called. Nobody answered. She told me to go to the church for the meeting. On the day of the meeting, one day the church was closed. It's only after I got a hold of Ms. Robb that I realized that they moved their meeting from time to time. So I have really not had time to get to them. But in this case, my major concern, and I can let the building sit. If that's going to be in perpetuity, I don't know. But still, we need to figure out who's liable for a building that I cannot insure within city limits because of zoning regulation. And I think you guys are the best person to tell me where to go to figure out what to insure that building, because he has to have insurance. Otherwise, this is a safety hazard for the neighborhood and for the people at large. That's something that we have to solve. Insurance for the building, because the way it's zoned right now, you cannot zone it, because the insurance man came and looked at it. There's restaurant hood, there's kitchen, there's everything is installed. You cannot make this building a single family home. I did construction for 15 years. You cannot, because I think this was 3 buildings at one point that got joined up to become one building. When you come in from the front side, you're walking about 15 foot, no more than that, you run into a literal wall that does not connect into the other part of the building. Then there's a step that goes straight up almost 2 floors that takes you up to the floor. You cannot make it a single family home. It's impossible.
If I may, I don't think that I certainly haven't heard it suggested from anyone that it be used as a single family home.
Oh, thank you for that, Gosh. I'm sorry.
Okay, anyways, anything for? Okay, thank you.
May I speak? Just shortly. I'm the president of the Western District Police Council. That's what that stands for, Community Relations Council. Also, I'm the Fulton Community Association president. So the message that went to Mr. Tanner, I sent it, the email. I just want to say I want to add some more emails from other residents and leaders within the Sandtown Winchester community, within the association, that are in support of what we were saying. I didn't just make these suggestions on my own. I don't make the suggestions. It's what's best for the community. And like I talked to Mr. Eagle, was talking with him, I suggested all the time that it's in a residential block. It need to be residential, be it 1 or 2 families in the building. However, the building has no front to it, no windows. So how are you going to have any kind of restaurant with no ventilation? And it's a hangout already right on that corner. So it's not a good thing. However, we're willing to work with him with the urban renewal and all that good stuff. But he wanted to get the approval for all these businesses in one area. It's no parking for that either. So that's all. I just wanted to leave that with the group.
Thank you. And I'll let the last statement be that, as Mr. Eggeru said, that there have been, I guess, the urban renewal ordinance has been in effect for a long time, and the problems in the area have been there for a long time, and that maybe the best way forward is to be more flexible and to consider some possible alternatives to try to address this situation. But that's really more of a...
Right. Well, I live right on Fulton Avenue, so I'm parallel to what we're talking about. Yeah.
Please, I'm just going to share this before you. I know you already said you're going to cut it off, but I met a lady who lived directly across the street from this property. She's lived there for 15 years. She's begging for someone to buy her property. She's been paying mortgage. Her mortgage is like $495. She's been paying that for about 15 years. Nobody would touch that building for $19,000. That's what we're subjecting people to. I mean, that is like abject subjectivity to poverty. If you live somewhere for 15 years, she's paid over $90,000 in the past 15 years. She can't even recoup that just to walk away. That's what we're doing. And I'm very frightened in talking to Ms. Robb here. She gives me no leeway to even come to the meeting. She hasn't even sent me the information she proposed she would send me so I can come to the meeting. It's not in my email box, I've checked. So it's like for some reason, I feel like there's some kind of, I don't know, to call it conspiracy, to new idea coming to the neighborhood. There's nothing that would change Sandtown other than businesses coming through and bringing up the property value. I feel for that lady. 15 years, she cannot walk away for a fraction of what she's paid over 15 years. That's what we're subjecting people to. And then we want to blame them for that problem. That's kind of, God, for heaven's sake, that's cruel. We have to do something, and maybe it's my fight, and I am gladly will take it on.
Excuse me, can I be dismissed? I have another meeting to go to.
Yes.
Thank you.
Thank you.
Thank you very much.
All right.
All right.
The record?
Yes. And I have developed 2 of those very buildings into single-family dwellings.
Please, Your Honor.
Thank you.
That's why I did not want Mr. Bob to recuse himself, honestly, because of what he just said. I've done construction for 15 years. I don't think he's better at construction than I am. He cannot. And financially, it's not possible.
He's not participating
But
in
he
the
just said,
discussion.
he just whispered something I heard that he has
He's
transferred
not
into
going to
family home.
participate in the discussion.
But I
regarding
mean,
the
unfortunately, he
decision.
has already whispered to the
We're
chairman's
off
ear.
the record and Mr. Barber has
Thank
been
you. That's
recused.
scary.
Thank you.
That's very scary. Not on that building into family home. That's scary.
Correct.
Okay, which ones do you want to talk about?
Well, we can start with 502.
Yeah.
Sure, start at the top.
I wish that they were able to get something done. The issue there is abandonment. And from the description,
In the community, they said it's been vacant for at least 2.5 years. And he said, the applicant said that when he first went there to lease the property, it was falling down inside. So it's the suggestion being that it's been vacant much longer than 2.5 years. But he certainly didn't resist.
I'm a no on that for abandonment.
Yeah.
That's where I was.
As I said, I wish that they'd have worked something out, because I think that the community is gonna be worse for it.
Yeah, I agree.
But, you know, they did, to their credit, they tried, and they said, you know, why they, in the end, weren't able to do it. And, you know, I have to respect their decisions, and you know, it sounded like they had a valid basis for it. There it was.
Seneca?
Yes.
I'm a no. There was no showing.
Yes, I'm the same. It's a very limited issue, but I'm a no because there's no addressing of the factors.
I was
criteria.
I was gonna be a yes, because it seems like an unnecessary hardship to have to pull up those footers and move that just
Yeah, but the
just
problem
for the
with
sake of moving it 5
You're
feet.
right, it's a hardship, but you can't make your own hardship.
That's right.
For the sake of doing it for 5 feet.
But if the permit was issued, so the work, then the work was done, and the permit was pulled.
I hear you.
Yeah.
Yeah, I think we've had cases before where
Yes.
permits were issued and we kind of said,
Mhm.
wow, you know, one agency issued a permit, maybe in mistake or,
Yeah.
you know,
But to say no means it's gonna pick it up and move it, in which case he wouldn't have needed to be in front of us anyway.
Right.
That's
Right.
So it just seems like to do that for 5 feet just seems unnecessary.
Kind of with Mike on that one.
It's a bit of a conundrum, that's
Right.
sure. But, you know, I can remember when, I think one of the first cases that we had was, at least when we were appointed, there was a house on, I think it was William Street. Actually, you know, the better one was that one on, there was a Cambridge Street in Canton, went on for forever. This guy made, he said that he built, I guess his mother was bedridden, and he built this, can't remember if it was a ramp and some sort of addition onto the house.
Oh, I remember that.
And
Yeah.
and there was the neighbor who was represented by somebody, not Gebhardt and Smith, but from, I can't remember. That's not important. But so he built this addition to the house so that his mother could live on the first floor of the house. It wasn't a big addition, it was small, but he sort of did it on his own, and the neighbors spent, like, you know, it's Canton, so they spent like all this money on their house, and they were upset because now their lovely view when they looked out the back was spoiled by looking at this rather small addition that projected out past their window that they could have to see now. And but there, it was what it was. That, you know, yes, it was a small addition and it was slight, and it was something that was built for the very noble purpose of, so this guy's 80-some-odd-year-old grandmother could, not grandmother, but mother, could live on the first floor. The opposition contested that, whatever, but that's what he said the reason for it was.
I just
And
don't,
it-
I just,
it
I
was what
still
it
kind
was.
of see that apples and oranges though, because they didn't have by rights the ability to go in and do all that stuff.
Well, he doesn't by right have the ability to go in and do all that here. He does so long as it's out of the setback area.
Right.
Same thing as this guy not built into the rear yard setback of his addition, and I think it only projected like, it was something small. It was only a few feet. And he wound up having to take the whole thing down. I think he appealed it up to like circuit court, and it went on for forever, and in the end, had to take it down.
He ended up with a porch instead of.
Yes. Because that's, I think that's what we told him, is that so long, that, the problem was that he enclosed it.
Right. But
But-
in this case, the examiner who reviewed the application didn't apply the setback requirements correctly. Just for the 5-foot piece of it.
Yeah, and I'm not condoning, I mean, the city made a mistake.
Shouldn't he have realistically been able to rely on that, though?
Well, they then, when they got a complaint, they realized they made a mistake and revoked his permit. By then, the damage was
Right,
done.
That's, he'd already done the work, or
but-
created the structures, the footers and whatnot.
I don't know how much of a hardship
No.
it is to move it 5 feet forward.
No, there is like the interplay of another area of law, with, you know, as far as like vested rights and all that kind of stuff.
Yeah.
With, you know, when you take action in reliance on governmental action, sort of, you know, how far you can do that, you know, before you become entitled to that position. So the answer may change if there's an appeal to circuit court on that. But, you know, that's not something that we apply here. We can only apply the zoning code.
Well, to David's question, his testimony was the hardship was financial.
Yes. Oh, I understood that.
I mean, I wouldn't want to have to dig up those footers and hire somebody to come, because you don't just lift up those trailers. You're gonna have to hire somebody to.
You need a crane.
Yeah.
Oh, I know. Or really, I don't even know if you can use a forklift. Probably not.
I'm gonna stay where I am.
I was actually hoping aesthetics did come into play, because aesthetically, it's pretty offensive.
Right, I'd be the first to agree with that. I
if
still
they
don't
can-
know that,
Can they complain to the national historic people?
Right.
Is there any enforcement there?
Not really. It gives them access to tax credits, but it doesn't control perhaps the property. They could tear the whole house down.
Is there liability to the city for negligence here?
I don't know that I can opine on that.
No, me either. I wouldn't issue
Like
anything
you
either.
just paint the things and tackle a big part of that aesthetic issue.
Probably, yes. I could imagine it looking, some steps you could take to beautify it, but that's not really the issue.
All right.
The next one.
100.
Listen. You know, again, I think that there are some odd things that you're sort of led to when you follow various different provisions to their conclusion. This may be one of them. But it's, you know, looking at what the statute says, it says that in all districts, no building can be converted. And then it says that in some, you can as a conditional use. This is one of those where this residential district is one where it says except in, I think it's R6 or
R6,
R4,
yeah.
whatever. So you can't have a conversion here. So it's just a simple question of, is the of record use a single family dwelling? Yes, it is. I hear you.
Yeah, I thought there was enough fuzziness that I can get to it too, on that one.
I'm in the same place.
It just seems,
Compounded by the fact that they can build a right
Okay.
what they're
That's
asking.
where I
Well,
mean,
fine. Then what
Go ahead
would
and
be
raise
so
it.
bad about that?
They couldn't replace that building economically because it's a better building than what they could build today, I think.
Right.
Yes.
Anyway, yeah, it's not as
I kind of equate this to the abandonment issue. I mean, it's similar in some respects to an abandonment issue, right?
Mm-hmm.
If it was once the two-dwelling, but it hasn't been for decades, right? Isn't that equivalent to abandonment? I mean, it's not the same issue, but it's the same argument, right?
yes.
Same principle, right?
Yeah, I guess what I'm saying, there was enough stuff put on the record to make it, you know, you can find.
Sure,
right?
you can question whether it was
truly
actually
abandoned
one
or
unit,
two.
or was it always two,
Right.
and it was just written up as one,
Right.
and so then you'd say, well, you know, it never really changed, blah, blah, blah.
But, you know, we're relying upon police reports from 1930 where maybe they didn't put an S at the end of the word unit or whatever phrase they
Sure,
used.
but you can question that with any number of different decisions. So,
All right.
to me, it's one, and if it, yeah, I'd love to see it built. I mean, that house and all those houses are very, very attractive. And they're lakefront, and I love it if someone restored them to how they looked, and it was a single-family mansion. If it gets knocked down and turned into a duplex that looks kind of shabby, then yeah, that's kind of sucks. But, you know, I think that it's a little bit arbitrary that the code says that you can have these conversions except for in these handful of districts. Just the same as we have the same thing, we have things that can be abandoned in certain districts, but not in others. You know, but that's not the decision I get to make. So, what else we got?
Well, Groveland, I don't know if he didn't officially withdraw. I don't know if we have to.
No, he did not.
Yeah.
Which one are you talking about?
The
Groveland.
one from that he was.
109.
No, what he was saying, no, he did not withdraw it. What he said was, if you can't approve it, then I'll just do it this way,
Right.
where I don't need you. And so I was like, okay, that sounds fine. So, okay, we're gonna say that we don't have the authority to grant what you're asking, and then you're gonna convert one of your 2-unit floors to 1 unit, and then you're gonna use the basement.
Right.
Okay.
All right.
I have 130 circled. I can't really remember why, but
Yeah, I had a question mark around that one too.
Yeah.
Oh, yeah, that was the one with the unclear permitting situation. So there was a vacant house notice in 2005 and again in 2014. And so they bought it from the prior owner, who it looks like pulled a permit in 2013, started doing some work, but despite that, there's still a vacant building notice issued in February of 2014. And then they die in the middle of it, well, sometime in the last couple of years, because he said that they just bought it in April. And so the question is whether or not, like, the 2-unit use was abandoned. You know, there's 2 vacant house notices that are generated on it, but there's certainly a question as to, some work clearly was started to comply with the permit, comply with the violation notice and to correct it, and then somebody died in the middle of that process.
Sort of facts and circumstances, I was okay with that one.
That one is one where, yeah, it's, to me, it seemed clear that there was an attempt by the prior owner to cure the violation notice.
Right.
By renovating the property and doing everything they needed to, and then they died. The testimony from the applicant is that 80% of the work is done. They just need to finish the.
And this guy picked it up in a reasonable period of time and started the work
Yes.
again.
just to play devil's advocate, those.
You've been doing that a lot today, Mike.
That's
fine.
Those notices typically for a vacant ban, basically are boarding up, secure the
Yeah.
building, that kind of
Yes.
stuff. Per his own testimony, minus a little bit of drywall repair on the inside, it sounded like all that was to address just getting the
Doors.
building secure.
Yeah.
I don't know if I counted that towards actually trying to get the unit back online.
Well, and I thought about that as well, but and I had asked him about, well, what was done inside, and he said that there was replacement of the drywall, and that there was about 75% done. They just needed to complete that.
Yeah,
So
I just-
it would have been better if we had photographs of what it looks like, to sort of get a better sense of what the situation is and what work was done. But it's at least close enough of a call, and there wasn't any opposition to say anything different, that I credited his testimony that, that there's been a substantial renovation of the property that just needs to be, they just need to do the last 20%.
I could be persuaded on that one.
But yeah, I thought about the same thing. It was not quite clear, but I wasn't gonna come down on him with that, particularly because it is a situation where he's coming in and someone, the prior owner died in the middle.
Yeah, I'm good.
Were there any other?
Anybody have any questions about the deck on Webster Street? I just have a
Other
question.
than the design.
Yeah, that was weird. It
Yeah,
didn't
that
look-
was very,
Yeah. The fact that it went into
Strange.
the alley was, are we okay with that?
It doesn't go
It
into
doesn't
the
go into
alley.
the alley, yeah. That drawing was a little weird
Yeah,
looking.
his drawing makes it look like it does.
It didn't, actually, I looked at it again, it didn't project into the alley.
Okay.
Yeah.
It goes right to the property line.
All right.
And it's weird that you step up to it.
You come
from
out of the steps and then go up to, or I guess
yes.
go down to the ground level.
Yeah.
Yeah.
It's strange. I mean, I guess it's more of like an elevated patio than a
I
deck.
guess, yeah.
Yeah.
But, yeah.
Whatever.
Okay.
I was okay with it.
Yeah, I was too.
All right. 2015-502, 910 Poplar Grove Street. I'm a no.
No?
Agree.
Yeah.
2016-88, 5506 North Charles Street. Was by consent. 2016-92, 3414 Seneca Street. I'm a no.
No.
I'm a yes.
I'm a yes.
I'm a yes.
Okay. 2000, just for the record, that means a no. 2016-1.
Wait. Say that again?
It was
You
3
need
to 2.
4 out of
Four.
5.
You need 4 out of 5.
So with 2 no's, it's
With 2 no's, it's a no.
disapproval.
2016-13104 North Hilton Street. I'm a no.
Agreed.
I'm a yes on that.
I'm a yes.
I was a yes too.
Okay. Making me the bad guy today. That's fine. 2016-107, 3006 through 3052 West North Avenue. I was by consent with planning department conditions. 2016-109, 4207 Groveland Avenue. I'm a no.
No.
Agreed.
No.
2016-112, 2053 East Monument Street. I'm a no.
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 2016-113, 2240 Cambridge Street. I was by consent. 2016-115, 13 York Court. Was by consent. 2016-121, 2421 Fleet Street was by consent. 2016-122, 134 East Austin Street was by consent. 2016-123, 1448 North Mount Street. I'm a no.
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 2016 that's correct. 2016-124, 1112 South Conkling Street was by consent. 2016-125, 343 South Chester Street was by consent. 2016-126, 2507 Foster Avenue was by consent. 2016-127, 311 South Washington Street. I'm a yes.
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 2016-128, 502 through 518 North Castle Street. It was by consent with planning department conditions. 2016-129, 1604 Webster Street. I'm a yes.
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 2015-130, 55 South Morley Street. I'm a yes.
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 2016-131, 909 South Highland Avenue was by consent.
So I thought in a situation where the urban renewal plan trumped everything, that rendered, we don't have authority, so therefore it's not a vote.
No, it means that we have to obey whatever the other authorities, so it's sort of, it's determinative.
Right, so we don't have a choice.
That's right.
Right. No, well, I want to clarify, because I wouldn't have
That's
commented the way I did if
Yeah.
I thought there was an actual vote and comment could somehow sway that. But I have made
For the record, your,
the same way.
yes.